And before we get started with the panel that's sitting here next to me, I'm going to introduce Stu Inges, who is our chairman and CEO of Venable, the name that you see right here, very pretty. And so Stu has been the chairman. He started inside of Venable back in 2006, that's 17 years ago. I've actually known him probably a bit longer than that. And he's one of those leaders that you always gravitate towards because of the way he operates and the way he works and the kind of leadership he shows. He's also a nationally recognized attorney, which actually sounds strange to say it about Stu, but he's a nationally recognized attorney who has a reputation amongst not only the industry, but also in the government as a thought leader, whether it's crisis management, it's privacy, it's marketing, it's advertising, e-commerce, internet, consumer protection. He is seen as a thought leader, as a person who brings people together to get a dialogue going, to figure out the right solution at the right time to the right problems that this country faces, or even internationally. The other thing about Stu is that he's been in a lot of cutting edge industries where self-regulation is critical to success. One of those is in the advertising area. There's security, public policy, privacy, all of these kinds of things. He's also testified, and I know this is Washington, D.C., and a lot of people will say this, he's also testified in front of Congress in a variety of committees related to media, communications, information services, advertising. He's worked with Congress in a lot of settings, the FTC, the state attorneys general, as well as other federal and state agencies. And then also, as we were starting, and specifically around MUSA, Stu knows how to bring coalitions together. And he's done this in a lot of environments that we were just talking about, but most specifically in the Association of National Advertisers. He's done it with the Interactive Advertising Bureau. He's also done it with the Digital Advertising Alliance and represented some as their existing outside general counsel, but just giving advice, counsel in terms of how do you bring that dialogue to the forefront of not only policymakers, but the media, the public, and the people who actually look for solutions instead of just finding the problems. So with that, I wanted to introduce Stu Inges, our chairman and CEO of Venable, to open the day.
Well, thank you, Hemu. I'm sorry it's raining here, but I guess it's better than snow this time of year. Hello to all of you out there on the ether. Apparently, we've got several hundred people watching here. It's great, Hemu, to have you at the firm, of course, and the whole Venable Blue team. Many of you are here today. It's really great to have you and all the great work you all have been doing in the last couple of years. So as Hemu mentioned, our event is being held around International Data Privacy Day, which occurs every year on the 28th of January. So it sort of just happened. And the point of that has been to raise awareness and promote privacy and data protection best practices. And so the subject that we're going to talk about today obviously fits right square in the middle of that. And what we really want to do today, and I think in the spirit of Data Privacy Day, is to promote awareness on an important issue. Conversations like the one that we're having today generate awareness that can be used here by policymakers, companies, and other, and hopefully move the dialogue on the broader area of internet best practices and regulation, which is a boat that we've all been traveling on now for 25 years or so. Unauthorized data scraping has become an increasingly important issue around the world, not just here in the US, as global demand for user data continues to grow for all types of purposes and ways that benefit consumers. And unauthorized scraping, however, can impact both users and the industry. For users, of course, it can break privacy trust based on expectations, and in worst case scenario can lead to harmful phishing or spamming type of incidents. For industry, of course, it can lead to a breakdown in public trust, which increases operating costs, limits the ability to be innovative, and sometimes results in limitations on practices or regulation that is ultimately bad for the public, for progress. So this is an area where we've recognized, and the team has recognized, and the participants in the effort have recognized that there is a real need for alignment. And consumers, industry, regulators, collectively do not have a shared and consistent understanding of how to control, measure, prevent, respond to issues around unauthorized scraping. So without alignment, it's hard to know what the best practices are to move forward in a collective way and hit that next level of practice. So that brings us to MUSA, although some people call it MUSA. I'm not sure. I kind of like MUSA. Hamo and I were talking about it. We're open for other names if people don't like either of those. As Hamo mentioned, there's a long tradition here at Venable and with our clients of bringing people together on internet policy issues at the very beginning of that. Some of the biggest companies, some of the smallest startups, and everything in between, we've worked collectively together to try and develop consensus around views that move things forward. And of course, Washington being a unique and great place to do that. I think MUSA may be our most recent initiative, but certainly among them. We launched it in September of 2022. And it has grown very quickly compared to the way some of these things take time to evolve. But we have many leading companies, experts that are committed to protecting data and defining the right standards. So what is it? It's a collaboration with industry members, policymakers, the public, to further a dialogue both here in the US as well as abroad, focused on the protection of user data and appropriate practices around scraping through education, advocacy, public-private partnerships, and development of reasonable practices. One of the early initiatives of MUSA is working on bringing all of you and the collective interest together to drive consensus and hopefully produce or publish, I guess is the term of art, industry-aligned common practices, definitions in this area. So I want to thank all of you for being here in the room virtually, recognize the really broad diversity of voices that are present, which is what results in the best product, from researchers, legal professionals, policy analysts, industry leaders, technologists, and others who are taking their time to be with us today and as this initiative grows. So without further ado, let me tell you about the panelists. We've got 3 panels. I'm told to remind you that there will be a brief 15-minute break following the second panel and a networking reception around 5 o'clock for those of you who are here in person, and the crowd is growing as the weather is hopefully getting better. So the first panel is moderated by our own, the great Julia Tama, who's been with us for many years and key partner in our practice. And the panel is going to discuss the current landscape and the role of policy and regulation surrounding the scraping issue. The second panel, moderated by, and I should have asked to get the name right. Is it Tejas? Tejas? Tejas, thank you. Tejas Narachania. Narachania? Sorry, I'm going to practice that. But really appreciate Tejas being here all the way from UC Berkeley School of Law, home of the great Chris Hufnagel as well, and going to focus on the relationship between unauthorized scraping and privacy and the impacts of data scraping for users and identity. The final panel, moderated by Hemu himself. He's the only one. Oh, we got a couple ties here, but Hemu put on a tie for all of you out in the cyber world. But Hemu flew in. He's based in our Los Angeles office and has been out there in various capacities for a number of years. Fortunately for us, with us the last couple of years. And Hemu is going to discuss the impact on industry and industry practices around data protection and the relationship to unauthorized data scraping. So with that, let me turn it over to Julia. And again, welcome everyone to this first annual MUSA Day. Thank you.
Great. Thank you, Stu. Thank you to everyone for joining us here today, and thanks to the wonderful organizers for putting together this event. I am delighted to be here. Without further ado, we will jump in. So on Stu's theme of starting to build kind of standards and common standards, we are planning to start with a question for Megan and then Chelsea to begin building a vocabulary for the rest of the day. So I would appreciate if you could talk a little bit about how do we define scraping sort of as an activity neutrally, and then within that, how do we define unauthorized scraping? So maybe thinking about the US first, Megan, we turn it over to you to kind of share, are there any legal or generally accepted definitions for what is scraping, then what is unauthorized scraping?
Well, considering that in the US there aren't any specific scraping laws, but there are scraping, I would categorize that there are actually a few subcategories. One is web scraping, and that's the collection of data, usually through the HTML of websites through crawlers, scrapers, pieces of code. Another type is screen scraping, where the contents of a screen is captured, and that could be done, it could be done either through public websites or by taking login credentials and going in and taking data that way.
Great, thank you. So you described the activity, and we established there are no sort of settled legal definitions in the US at all. Chelsea, what about internationally? I know you've been looking into this. If we look outside the borders of the US, do we see any legal or accepted definitions of what is scraping and what is unauthorized?
So first to note on the authorized versus unauthorized. So there's certainly authorized scraping, and you can have scraping for many different purposes. Our focus today, I believe, is on unauthorized scraping, and I think there's a real question of what is authorized versus not. And companies who sit on platforms can define those activities differently. But similar to the US, internationally, there is no real legal definition around web scraping. There are no laws, generally speaking, that govern this type of activity. But we are starting to see in some of the Asian countries like South Korea think through this issue a bit more, but we've not gotten to a place where generally there are clear distinctions with unauthorized scraping in international law. I think something interesting about this issue is we're talking about different jurisdictions, but it is a global conversation. So when it comes to the internet, it's very difficult to have physical jurisdictional boundaries. If you look at the rise of the internet and you see country A does things a certain way, country B does things a certain way, and so you see actors going to country A in order to do certain activities, and you're starting to see that issue with web scraping as well. So part of addressing this is just having the global conversation and recognizing that these can't all be separate issues that every country addresses individually. One more note I'll say on that is, as the US is making decisions about how to treat web scraping, you have countries that are actually watching what the US is doing to figure out how they want to address it as well. So one example of that is Australia and New Zealand. So they oftentimes look to the US for how they interpret decisions. One example is in the contract space. There's court decisions on how the US discusses contracts, and then applied to the web scraping context, if we're thinking of terms of service and what's unauthorized and what's authorized, they're thinking about these issues in the same way. And the way that we know this is they're actually citing US opinions in their own court cases for how they're thinking about the issues. So I think it's interesting on how the US is affecting the rest of the world in that way.
Very interesting. Thanks, Chelsea. And then again, just kind of to round out this theme of, common vocabulary, making sure we're all thinking of the same things. Megan, I'll turn back to you just briefly. Are there any kind of common misunderstandings that people in this room or online might have about scraping that we might want to address right at the beginning? Any distinction between what you defined as scraping and, for example, like, a hack or a data breach or, other types of events that could happen that could affect data?
I mean, there are numerous types of unauthorized collection of data, and I think one thing that's kind of useful is seeing web scraping and other types of scraping as subcategories of that unauthorized collection of data that result in very similar types of harms, like autonomy harms.
And through those very technical means that you mentioned at the beginning. So it just occurs to me that's also something we should have in mind, is that this is a very automated process, right? Great, thank you. So now we'll talk for a bit about the legal landscape of scraping. What is it? What could it be, et cetera? So Coben, I'll start with you and then come back around to Tim. So in terms of the legal landscape, I think we can think of scraping as potentially triggering a lot of different areas of law, right? Stu mentioned privacy, the second panel will drill down on that. There's some other legal issues that also could potentially be raised by this activity, right? Could you maybe give the group just kind of an overview of the different types of legal issues or policy issues that could be raised by scraping?
Certainly, I can certainly take a stab at it at least. And thank you again for having me. This is wonderful. I'm excited to focus on this issue today. And I'm a privacy person. I'm pretty much a generalist. So my love is on the privacy side, but yeah, this is a fascinating issue because it really doesn't fit very neatly into any legal buckets. I think and I think courts, you've seen that through the history of the internet, the courts have struggled with trying to approach this in different ways, whether that's through property type rights, through contract, through torts. It touches on all of those things, and it doesn't quite fit with traditional aspects of common law in those areas. We will probably hear a lot today about the Computer Fraud and Abuse Act, the CFAA, which kind of arises from property. It's about cyber trespass, and as we'll talk about later, I think we've found that it certainly doesn't quite, at least according to the Ninth Circuit and the way that things have evolved, that doesn't quite incorporate what we're an actual remedy for scraping. I found that the case in the Ninth Circuit, the High Q case versus LinkedIn, is actually, I was reviewing that again today, and I found it interesting because they kind of the court actually lists a number of potential other avenues for redress around the types of harms that you see in scraping. And so I thought I would just list those for you now, just to kind of set the table. And I think Tim might have other things or his own approach here to help us conceptualize this. But they list trespass to chattels as kind of the traditional trespass element, copyright infringement, misappropriation, like trade secrets, unjust enrichment, conversion, breach of contract, and then privacy. And some of these are tried and have been tested in court. Some of these have been less tested, but we're sort of still seeing that evolving in the US and elsewhere. I would also point just to the fact that there's multiple interests at stake when it comes to scraping. Stu's remarks talked about user data. There's this question of what interests users, consumers, people that have created content that's sitting on platforms, what interests they have and whether they have remedies against people who are scraping. And then also the interests that the platforms themselves have. And those sometimes overlap and sometimes are distinct. But that's the big questions that we have that we're trying to solve here.
Right, the topic for today. Thanks, that was really interesting. So Tim, turning to you, we can hear that this is a challenge in search of a legal framework, right? Can you maybe take us back a little bit and talk about where the legal, landscape is today? Obviously, I think everybody in the room probably knows there have been some recent major cases, but how would you describe this legal landscape of scraping today?
Sure, thanks a lot. I'm Tim Edgar. I teach law and cybersecurity at Brown University and also at Harvard Law School. We have an online master's at Brown University, which I need to plug here. And one of our students in the room who is one of our great students in that program. One of the things I do in that program is I look at a variety of legal frameworks. I tell my students, the thing I love about cybersecurity and privacy is it's great for somebody who has a little bit of ADD or just doesn't wants to always go back and forth between different legal frameworks, because there you go. You've got your whole, everything from the law of war to regulations of various kinds and everything in between. Unauthorized scraping is no different. Unauthorized scraping, we heard, I think, very, very well described by Megan. And it's just, I think it comes from, backing up for a minute, the internet was not built with security in mind. Those who architected some of these protocols and standards, they thought all you had to do to avoid someone who wants to do web scraping from scraping your website is to put in a little tiny string of code, robots.txt, and then, of course, when the program sees that, it won't scrape it. And of course, that works fine if everyone's cooperating. If everyone's part of a kind of academic, cultural endeavor of the internet, which is, of course, how it started. So it really wasn't that crazy an idea. We have two principal frameworks that I think about with unauthorized scraping. One is hacking law, and the other is privacy law. So I'll just talk very briefly about that, because I know you're going to hear about both of them in a lot of detail. The one we've heard most about in the courts has been hacking law, the Computer Fraud and Abuse Act, the principal federal anti-hacking statute. And what that does is it criminalizes, it makes it a crime to either engage in unauthorized access to a computer or information system, computer system, or to exceed authorized access. Those terms are not defined in the law. Those terms date back to 1984 when the statute was originally passed, but actually they're good terms. They're meaningful terms in computer science. In the case the Supreme Court heard involving a different prong, involving the exceeding authorized access part, in an opinion written by Justice Amy Coney Barrett, I think she took a very good approach of saying we should really look at that term of authorization from a computer science standpoint. This was a huge insight, because for literally decades, the courts had struggled with the term authorization because judges are lawyers, trained as lawyers. So are lawyers appearing before judges, obviously. And authorization, authorize, these are words authority, these are words we think of in terms of the law. But they're also terms used in computer science and in computer architecting computer systems, and they have a distinct and different meaning in those contexts. And essentially what she said in her opinion is authorized should be given a technical meaning because it's a technical statute. In the case she was dealing with, it was a police officer who abused his access to a database. He was authorized to use the database. He did not exceed the authorized areas of the database. He just abused his access. He misused the data horribly in a terrible series of facts. So she said that's not a violation of the CFAA. Maybe there are other crimes, but that's not the crime of hacking. A police officer who logs onto a database, misuses the data, is not a hacker. Okay, so LinkedIn and HiQ come along. HiQ is a startup that scrapes LinkedIn's data. It's publicly available data. LinkedIn has put a robots.txt, we don't want you to scrape us, little request in their text. They ignore it. Then LinkedIn does various technical means to try to block their access. They ignore those too and try to circumvent them. So here's the day. Is that accessing the information in an unauthorized manner? It was going to go to the Supreme Court, and I have to say I was really annoyed when the Supreme Court agreed to hear that case. Great, fantastic. We're going to get more guidance on what the CFAA means. Another case with different facts about the CFAA, that's what we need. And instead of hearing a second CFAA case for the first time in 40 years, they remanded it to the Ninth Circuit and said, we already decided a CFAA case. Look at our opinion in that one. Give us an answer. And I think they genuinely thought that their decision in that case, or at least some of their clerks or justices thought, yeah, it's obvious what the answer is from our case in this case involving the police officer. I don't think it was obvious at all. It was a different part of the statute. It involved different issues. But the Ninth Circuit looked at it and essentially said, well, if you need to be authenticated first, before we then look at whether you're authorized to use data, here you have public data. There's no authentication in one sense, and I don't want to dominate, so I'll get into authentication in a second if you want me to. So therefore, there's no CFAA violation. I think that was too hasty, I would say, on a legal rate. The other rule, and I'm not going to get into too much detail on, is privacy law. And I think no matter which side you fall on the CFAA issue or the hacking issue, many commentators, many privacy groups who hate the CFA, want a very narrow interpretation of the CFAA, reluctantly may agree with HiQ because they just don't want the CFAA to be too broad, would say, well, this shows why we need a comprehensive data privacy protection law in the United States, because there are so many areas of private data where using our criminal hacking statute could create all sorts of problems, but we don't want to leave the data completely unprotected like it's the Wild West. Just because it's not a crime to go and do certain things with data on the internet doesn't mean that the law shouldn't regulate it, or at least give a civil remedy to companies or organizations who are dealing with, a company that's actually trying to exploit that data. Maybe we don't want to put them in prison. Maybe we don't want to say they're hackers. That doesn't mean that we want to validate their business model of exploiting personal data. So with that, I'll close.
Thank you.
Yeah,
That was very...
it's a danger. I'm used to, 40, 90-minute lectures. So that was actually pretty short. So.
Well, it's great to have a master class in it. So thank you for the recap of the recent law. And I'm glad we got that out right at the beginning, because obviously those have been some major legal developments recently that it's good to have that framework in mind right at the start of the event. And so, you shared how there have been kind of recent happenings. What are we watching now? So Megan, maybe I'll turn to you. Are there any cases kind of on the horizon that might help to cut through some of this? Or, is it kind of like the world of scraping and legal is paused right now, waiting to see what happens next? Or what kind of things are you tracking?
I'm not personally aware of any additional CFAA cases. We were involved in the HiQ case from the first time it was in the Ninth Circuit, when the injunction requiring LinkedIn to give HiQ access to its user data was being appealed. And we got involved because the balance of the equities analysis was a little bit wonky there, because the court below, the district court, decided that HiQ's business interests outweighed the privacy interests in user data without actually doing any kind of analysis of the privacy interests in the user data. But given the Van Buren decision, given the latest HiQ decision in the Ninth Circuit, the CFAA does not seem like a great way to deal with scraping. What we really need, as has been mentioned, is a privacy law that would deal with it. And this past year, we saw a comprehensive privacy law introduced in Congress. A great deal, the most work that has been done on a comprehensive law in decades. And what was the main, one of the biggest carve-outs was for publicly available information. And this is a constant issue with trying to get scraping included in comprehensive privacy laws, or any kind of privacy law, and that is the immediate gut reaction that there's a First Amendment issue here. And that has yet to be sufficiently challenged. Certain groups pretty much go to Congress and say this is a problem, so we can't do anything about it. But I think what's interesting here that I'll point out, it's not CFAA cases or anything, but some recent First Amendment challenges to privacy statutes, such as non-consensual pornography statutes, that have actually prevailed, even under strict scrutiny, because the privacy interests are so great. And I believe that the same thing could be said for any kind of privacy statute that would try to regulate scraping. And that is because the recent case of Clearview AI and a whole bunch of other AI companies that are essentially just scraping everybody's personal information off the internet to feed into their machine learning tools. Now, there again is the immediate autonomy harm of collecting someone's information and taking away their choice as to whether that stays on the internet and how it stays on the internet and who has access to that information. And then an abundance of downstream harms from the subsequent use of that information to create facial recognition profiles and to make other harmful inferences about people. And if that can't First Amendment scrutiny, like what can? So I think it's time to challenge that assumption that we can't have laws that regulate this.
Yeah, so you would prefer, coming to one of our next questions, you would prefer for the legal framework to make clear distinctions between permitted data collection and then unauthorized scraping. And in particular, you spoke about how that should apply to data that is publicly available and that shouldn't, in your view, it shouldn't be the dividing line. I'd be interested to hear what others think about that. Should we have some kind of a statutory framework that's clearer here and that defines the authorized line versus the unauthorized line? Is it time for that? Anyone? And Chelsea, maybe you have insights from overseas, that you maybe have insights from your international research or the US.
Back to what you were saying about some of the other legal issues here. So for unauthorized web scrapers who are using the data in nefarious ways, I think there are a lot of other issues to bring up for enforcing against these types of actors. One issue is the logged out versus the logged in ways. So unauthorized scrapers who are using the data in bad ways, they're becoming a lot more smart about how they're getting this data. So they're logged out while they're scraping it. It makes it a lot harder to enforce via terms of service or other mechanisms against them. So I think that's something that's a challenge right now with unauthorized scraping. The other is the consumer harm here. Proving harm. If there's proof of how the scraper uses the data, especially for fraudulent means, or if there's a privacy violation hook, it's a little bit easier to try and argue that it's for, there's a web scraping claim there for unauthorized access. But part of the difficulty is that the data gets mixed. And so it's hard to prove consumer harm with data mixed coming from different sources and knowing really where the harm lies there. Part of the other issue internationally is that, like the US, there's no clear web scraping laws. And so companies are trying to figure out, how do we fit this into categories? Is it the breach laws? Is it consumer harm laws? Is it property laws? And that's been very difficult to do because there is no clear tie into those for many of the international jurisdictions. We're seeing in some of the Asian countries, specifically in Thailand and India, there's many laws around computer crimes. But that gets a little bit harder to tie it into unauthorized web scraping because it's difficult to know how people are using the data. If it's for fraudulent means, are they, like I said, the logged out versus logged in, how are they getting it? Where is it going? So the harm piece there really makes it difficult internationally as well.
Thank you. Very interesting. And we'll talk more sort of in another, in our next phase of the session about like maybe what the law should be. But in the meantime, I would be interested to hear Tim or others, if you want to jump in, today, right, in the absence of a further law being enacted yet, what are the alternative legal grounds that could emerge, right, to address unauthorized scraping?
Well, we heard a little bit about other theories of liability. My own view is that the CFA is still kind of a live issue, despite what the Ninth Circuit said, precisely because the distinct facts are actually quite different from Van Buren versus United States. That's a Supreme Court case. Van Buren was about exceeding authorized access. This is a case about accessing without authorization. So it's actually a different part of the CFAA. Also, the idea in Van Buren was look at the word authorization from a technical standpoint. And the question is, does the person who's being authorized, have they been given the right to go into folder A or folder B? I think it was X or Y, actually. And if they've been given that right, we're not going to look at the way they abused their terms of service or something like that. That was essentially the insight. Basically, from a technical perspective, when we're talking about authorization, that's a fundamental part of computer security or cybersecurity. And we usually think of them as the 3 A's. We think about authentication, we think about authorization, we think about access control. And the CFA is kind of strange because it never uses the word authentication. It only uses the word authorization, and it also talks about exceeding authorized access, which kind of seems like access control. So I think the Ninth Circuit made a huge leap of assumption that what Van Buren was saying was, if there's no authentication gate, it's fair game, everything applies, there's never a CFAA violation. But the Van Buren court said nothing of the kind. And I was sort of curious about this issue. I quizzed a number of my colleagues who are more technical than I am, although I do have the lofty title of professor of the practice of computer science now, which is interesting when your only degree is a JD. But I quizzed them because I thought, well, surely there's an answer, a technical answer to this obvious question of, is authorization something that you only ever talk about before authentication happens? First of all, there is not a clear technical answer to that question. If you look at various technical manuals, some of them seem to apply that, some don't. But the second point is that authentication is much more complex than username or password, or you are who you say you are. Those are nice shorthands, but authentication refers to basically a whole series of steps that a computer uses to decide whether to grant access. And to be authenticated, it might mean, okay, I've told you who I am, I have an account, but it could also mean I've showed you that I have a particular token, but you still don't know who I am. Or it could show you, I've shown you a whole bunch of characteristics of who I am, now authenticate me. And many of those techniques were techniques LinkedIn was using to prevent scraping. Those techniques could be determined by most, I would say maybe all computer science researchers would say, those are authentication steps that were being taken. So I think the Ninth Circuit kind of just breezed right through this and said authentication means publicly available data is fair game. That is not what it means at all from a technical standpoint. And if we look at what the Supreme Court said about how to read the CFAA, we're supposed to read it through a technical lens. So I do think that the legal issues here are more uncertain. Maybe in a future scraping case, maybe in a different circuit, we might end up with a circuit split. And who knows, by 2055 or 2065, we might have an answer from the Supreme Court about the circuit split, given the general pace at which these things go. So that's my sense about the legal issues there. Just in terms of the policy issues, just quickly, I do think that one of the big problems lawyers have and judges have is they hear the term privacy and their brain shuts down and immediately goes to the Fourth Amendment. And they say, aha, privacy, I know what this is. It's cats, it's reasonable expectation of privacy. It's what the police, what do you need when the police need a warrant to get something? Well, obviously, publicly available data, what you're doing in public streets, there's an enormous host of things the police don't need a warrant to do when they're engaged in an investigation. That does not mean that the law can't and doesn't already regulate many of those activities. Many are highly intrusive. Many involve serious invasions of privacy. That's why the police have extensive investigative guidelines. J. Edgar Hoover, I've been reading his fabulous new biography. So many of his files were basically publicly available information, aggregated in a way that was deeply revealing. So the law, just when you hear the word privacy, don't immediately jump to the Fourth Amendment. There's so many areas of law and so many privacy interests that are implicated by aggregation of publicly available information, especially on the internet, especially in 2023.
Yeah, and that ties directly to what Megan was saying about publicly available information, because the argument goes that if it's public, then you have no reasonable expectation, right? You've put it out there on the internet somewhere, and so therefore everywhere is fair game. And that goes against a lot of what we've learned about how privacy works, how people's expectations of privacy are informed, and the kinds of harms that can flow from data being shared in ways that aren't expected. The privacy is deeply contextual, right? So one of the potential harms from these types of technologies when we're thinking about use cases, and it will probably, I'm sure other panels will go deeper into some of these recent use cases, including Clearview AI, but also generative AI like ChatGPT, which is in all of the news right now, maybe less so concerned with personal data, but still scraping lots of data from everywhere. One of the big risks is that it's something that decontextualizes information, right? It takes something from one context that's been shared in a very specific context, like a LinkedIn professional profile, and enables that to be used for matching, in the Clearview example, matching faces that may be anywhere else on the internet. That is something that kind of goes against the way that humans think of their interactions with the world. It's not, it goes beyond, and that's, I think, why we start to wonder about that in the privacy context. However, as we're thinking about privacy laws coming along to save the day, it's really important to consider what Megan said, which is that there's generally, in most data privacy laws, a publicly available exception. And until we change that conception, it's unlikely that privacy is able to, the data privacy laws are going to be able to address some of these issues.
Yeah, that kind of brings us directly to the question of, what should happen next, right? So CFAA is an imperfect fit. Privacy law today can be an imperfect fit, even though we've talked about what privacy interests can come up in the context of scraping. So what is or what should be the role of government, both regulators, policymakers, maybe even in their enforcement role? So it's kind of a question for the panel. What could the role of government authorities be in combating unauthorized scraping? We've seen various private litigation, right? IQ versus LinkedIn, other examples, many other examples, right? What could the government be doing right now? Is it mostly, would we be looking for passage of a law, or are there other things that authorities could be doing or should be doing right now to help define and combat unauthorized scraping?
Well, for true threat actors that I keep talking about with unauthorized scraping, who are taking the data and using it to do bad things with it, there simply isn't enforcement mechanisms. And it's very difficult if you don't fit clearly into one of the hacking statutes or some of the others that we talked about to enforce against these actors. So having a way to do that, having a conversation with the global industry and community about how do we work together to do this and have mechanisms that we can even do something about this, I think is one part of it.
Great. Anyone else want to jump in?
Well, something it's not on web scraping, but on data scraping. The CFPB is doing something interesting right now and following in the footsteps of other countries in considering mandating that banks create APIs so that third parties can access user data through the API instead of scraping the data. This is for one, security reasons, because currently some banks, some third-party applications have taken user credentials to then go into the account, scrape the data. This is insecure. Giving your credentials to anybody is a terrible idea. The credentials are at risk, and also the data can be misused. But also, the bank, the data provider doesn't have technical controls over what precise data the third party is taking. There's monitoring mechanisms, or they don't have the same kind of things. So it's a very interesting idea that perhaps one thing that can be considered in conjunction with proposing laws that ban web scraping is to, at the same time, mandate some kind of open access to data to ameliorate and to acknowledge the access interests on the other side.
And that's interesting because it's sort of an example of it's top down, but in any case, there needs to be some way for those two actors, the scraper and the scrapee, to be on the same page as to what's authorized. I think that looking at that from a privacy perspective is interesting because I feel like as we move toward that, even if they are on the same page, it may not be. It's going to be important to to include in that proper notice and understanding for consumers
And control.
that that third party sharing is happening, right? Because right now it's unauthorized, so it doesn't really even touch from the privacy perspective. The controller is not sharing it to the processor directly, but then if they do have that relationship, if they through contract or through force of law are entering into this arrangement, the consumer is always going to need to be part of that equation as well, and that's something that will need to be navigated.
Yeah, I guess I would make a plug for research, which I suppose is what you would expect from an academic. But I think that it would be very important to understand the full scope of the problem and also its effects on cybersecurity. I think it would be very good if some of the federal agencies or Congress could look at this problem and say, what are the malicious actors? What are the harms that are resulting from leaving this practice essentially unregulated? Because I don't think that voluntary approaches are going to be sufficient. If they were, scrapers would just respect the robots.txt, that's already there that says, hey, please don't scrape my website. So I think that, there may be other ways to improve that. Don't get me wrong. I'm sure there are, with APIs and other mechanisms. But I do think there's going to have to be some kind of government action. And whether that can be done under existing regulatory authority, I think the Biden administration has shown there's a lot that can be done with existing regulatory and government authority without even having to get Congress to pass a law, or whether that's a law. We need to understand what the worst examples of this kind of scraping and what happens is. We need a decision, an explicit decision that, do we want companies like Clearview AI to exist? If so, what are the rules and oversight that should apply to them? How does this work in terms of policing reform, intelligence reform, and all of that kind of stuff? I worked for years inside the intelligence community on privacy guidelines and regulations. I can tell you, we worried a great deal about the intelligence community's access to publicly available information. Because of what was going on the internet. Yes, they can do it. Of course they can for valid intelligence purposes, but there's plenty of abuses as well that could be done through intelligence community access to that kind of data. So those are the conversations we need to have. More data, more research would help.
Great. Okay, lots of great ideas there, which I really appreciate. I see that we have a few more minutes left, and I think if we have any audience questions, I'll just pause right now and see if we have any. If we don't, I can continue. Yes, in the back.
Hi, I heard one of you mention the bank API and scraping issue, and you may or may not know, hopefully I'm not
Hey, we're bringing you a microphone because we do have a large virtual audience. Want to make sure they can hear you too. Thank you.
There we go. Beautiful. One of you mentioned earlier the banks and APIs and scraping, and I was curious if any of you are familiar with the CFPB's recent 1033 proposal and whether if you had any reaction to their request for comment on the validity and possible uses of screen scraping.
Yeah, exactly. So I kind of brought it up in the context of the CFPB was doing this just like a few other countries mandating open banking. And yeah, we submitted comments recently encouraging the CFPB to mandate access through portals and to cut down on screen scraping for the privacy and security reasons. But if other people have a any reaction then.
Sorry, yeah, I was trying to formulate thoughts. Yeah, I think, I just, yeah, I would reiterate, I guess, again, that I think it really is a good example of a top-down approach that would try to create shared understandings of the relationships between the two parties. I think inherent in that also sort of that we were just teasing is this idea that I think there is some reason to try to figure out what legal remedies are out there and what paths to kind of having a stick are available, even if we create wonderful voluntary relationships, or through the CFPB or other specific agencies create these mechanisms where people are going to play well together. There needs to be some way to enforce that, right? There needs to be some way that if there are bad actors or small, now it's becoming increasingly feasible to do this type of, to create a company that does this type of work with very limited resources. We need to be sure that there's that those kinds of bad actors are kept in mind as we're thinking about possible solutions.
Right. And we had a question in the middle here, please.
Hi, my name is Roktama. I've been practicing internationally for the past few years, and I'm right now here at Georgetown to sort of specialize in tech law and policy. So because my experience is more sort of international, one of the questions that I had, because you guys did speak a lot about, cross-border issues, one is that this exception that exists for publicly available data, because at least with the Indian government, I have engaged a lot, and there are certain reasons why there are certain kinds of people that they're trying to protect when they create that exception. But obviously, it does lead to this situation where it's very difficult to take action against unauthorized scraping. So when you say that a privacy law is the solution, I was wondering what kind of, how you would structure this. Would you want the publicly available exception to go away entirely and maybe have enforcement exceptions for, say, researchers? Or would you want the publicly available exception to stay, but maybe specifically for commercial use have some enforcement action built in, or say that it doesn't apply for that? So that's my first question. And my second question was, again, coming from basically an international background. One of the things that when we were advising clients, a lot of them were essentially doing these activities through subsidiaries in some corner of the country where it's difficult for governments to reach. And now in an increasingly globalized world where users are spread out everywhere, the actual companies against whom these acts are happening, like LinkedIn, etc., they might be maybe located in one particular place, but users are in different places. The government which is trying to reach them may not be able to reach them if they're in some other corner of the country, of the world, sorry. How do you think that that's something we can sort of figure out? Because that was very actively done by a lot of people who sort of came to us for advice, saying that, okay, this is where we are located specifically to, escape the reach of governments and enforcement action.
On the privacy law and whether there should only be only commercial use of publicly available scraped data should be regulated. I would point out that there are many harmful uses that are non-commercial, including some research that's done. A lot of the research that's going on. A decent amount of the machine learning type of work that's going on is done by researchers at universities. There have been ones, and I'm probably going to mistake it exactly what the research was, but it was scraped people's faces throughout the social media profiles, publicly available social media profiles, to try to figure out whether they were gay. And that was very concerning. But so yeah, it's not merely commercial use that's an issue. And I think if there's going to be exceptions, it should be perhaps more like giving the FTC or whatever privacy authority there is some kind of rulemaking authority and ability to make exceptions based on certain Thanks.
I mean, just building on that, I think on this question of what's the alternative to having a publicly available exception, I think if that type of information is within the scope of privacy rules, it can come under the types of restrictions around purpose limitation, limitations for sharing, a kind of a more data minimization focused approach, where the secondary use, the use by the scraper, if it's not in keeping with the purposes for which the data was shared and collected, might go against the privacy law. But even laws like ADPA that start to have that sort of approach have also shown this publicly available exception. So
I have to say, I'm surprised, dismayed, and appalled at the research you're describing. It seems like it's an obvious violation of human subject guidelines.
You would think the IRB would have a problem.
The institutional review boards are required to review research involving human subjects. And of course, in 2023, human subjects don't have to be there physically. And that strikes me as being just an obvious open and shut case, but obviously that's not what they thought. Just one very quick point. I do think it's very important to sort of kill this idea that publicly available data could never be looked at because of the First Amendment. All of our privacy torts that go back for 100 years involve publicly available data. Intrusion on publicity, intrusion on seclusion, and you go down the list of classic privacy torts where you can sue and get a remedy for that invasion of privacy. There's no publicly available exception to that. That would kind of gut the entire concept of those torts.
On the international question, I think that's exactly the issue. You have different countries approaching it different ways, and so people are going to one country to do it because they don't have laws on it, or they have laws. So India, you mentioned, has some computer laws, but they have hardly any enforcement in that area whatsoever, and so it makes it very difficult. So how we solve that, I think, is an ongoing conversation, but the point is there is a conversation that takes place, happens at a global scale. Maybe it's a Brussels conversation, maybe it's through coalitions. There's a lot of ways to tackle it, but that's exactly the issue that needs to be addressed.
But ideally some coordination and some clarity. So we're at time. This has been a really fascinating discussion. Thank you so much, Chelsea, Coben, Megan, Tim. Really appreciate you being here. Want to make sure we leave ample time for the break and the other sessions, which I'm sure will be equally fascinating. Thank you, everyone.
Wonderful to meet you. Obviously, we're working on some similar things.
Oops, thank you. As we transition to the next panel, it'll be virtual, so the screen will come down and we'll see our virtual panelists. But I just want to thank you by name. We had Julia Tama, a partner here at Venable, moderating. We had Megan Aorio, who is the Senior Counsel and Amicus Director at the Electronic Privacy Information Center. Chelsea Reckel, who's an attorney here at Venable. Timothy Edgar, who is a professor of the practice of computer science at Brown University, a senior fellow at the Watson Institute for International and Public Affairs, and a lecturer on law at Harvard Law School. We also had Coben Zweifel-Keegan, who's the managing director here in DC for the International Association of Privacy Professionals. So thank you all so much for being here. So good. All right, this panel is the impact of unauthorized scraping on users. Our moderator is Tejas Naranchania. He's the UC R&N course and assistant professor of law at UC Berkeley School of Law. Hannah Shimko, who's the communications and policy director at the Online Dating Association. Callie Schroeder, who's a senior counsel and global privacy counsel at the Electronic Privacy Information Center. Brandy Noneke, who's the founding director for the Citrus Policy Lab and associate professor of technology policy research at the Goldman School of Public Policy at UC Berkeley, as well as Sarah White, who is VP Legal Litigation and Competition and Enforcement at LinkedIn. Thank you all for being here.
Okay, I guess I'll just kick us off. Let me start by saying thanks to the organizers and to everyone for being in the audience, both virtually and in person. And thanks for tolerating our presence virtually. I know you're all in a conference room looking at a screen, which is not always the best, but I think we're going to have a great conversation. I'm really thrilled to be moderating this conversation with 4 amazing panelists. So Sarah, maybe I'll start by asking you a question, which is just, LinkedIn has obviously been involved in some high-profile scraping things, as the last panel talked about. Maybe you just give us an overview of sort of what's important for people to understand about scraping, and in particular, unauthorized scraping.
Sure. So I've been at LinkedIn for almost a decade now, and I've been actively involved in working to stop abusive, unauthorized scraping pretty much that entire time. One thing I just want to note is that the opinions I express here are my own, and I'm not speaking on behalf of LinkedIn or its parent company. I could spend our entire 45 minutes answering just your question, but I'll try to do it in just a few. And I think there are 3 key things that I would emphasize. And the first, was addressed in the first panel a little bit. It's just that it's complicated. It can be hard for people to reach a shared understanding of what scraping means and when it is authorized. And for me, boiling it way down, scraping is copying information on a website using automated processes, usually at scale. And it's unauthorized when the website owner has made clear that they don't want you to copy it, whether that's through terms of service or code-based instructions to bots or technical measures designed to detect and throttle or prevent automated visits to the website, as opposed to human traffic. One really important thing to understand that I think often gets lost in these news cycles that come up, periodically, is that scraping is not a data breach. It does not mean that an attacker has been able to get inside a company's secure systems or subvert firewalls or access, sensitive protected network information. And then relatedly, a website owner has not done something wrong or failed to do something they should have just because someone came onto their website and scraped information from it. It's quite literally impossible to stop all scraping through technical measures. And the reason for that is that once a web page is rendered to a user, and whether that user is real or a bot, it's just not possible to control technically what that user does with the information. So we can impose limits and we can detect patterns suggesting bot as opposed to human activity so that we can then block suspicious IP addresses. But even then, the effectiveness of those technical measures has to be weighed against their potential negative impacts on site function and responsiveness, which also is obviously very important to users of any website. And then the other key thing I would say that's related, another key important thing to understand is that even though it's not a data breach, unauthorized scraping is often a violation of rights. I think that, often got lost in, public discussion of the HiQ case, these false, headlines saying, oh, court rule scraping is legal. Scraping, unauthorized scraping can violate the rights of the website owner who didn't authorize it. The website owner who may have taken considerable steps to prevent scraping contractually and technically, and who, likely invested a great deal of time and money in their business and their website and the people who use it. And when that scraped data in particular is about people, it can violate their expectations about who can handle their data and what can be done with it. It can harm them, it can annoy them, it can open them up to unwanted intrusions. And in the case of LinkedIn in particular, our focus is enabling members to represent themselves and create their professional profile of record, and giving them the power to represent themselves in the way they feel is most appropriate at any given time. So they expect to be able to control how they represent themselves and how they engage and navigate important professional relationships. And so when people scrape profile data from LinkedIn and use it for other purposes and other locations, they're taking away that control from our members. So just to use HiQ as an example, because it's a convenient one, they used data scraped from LinkedIn to tell people's employers who was a flight risk based on things like changes they made to their LinkedIn profile. And that really thwarted people's expectations that small changes to their profile, while public, would not be noticed. And it just introduced the possibility that employers could take negative actions based on that information. You know, people sometimes post inaccurate things by mistake, or they want to fix something or emphasize different aspects of their experiences. And the inability to delete scraped data about yourself really prevents people from moving beyond their past selves. And then I guess one other related note, you know, the unauthorized scraping, again, although it's not a data breach, it's not a security issue by itself, it does have the potential to increase risk of things like fraud or identity theft. And that's particularly true when data scrapers are willing to sell the personal information that they're collecting or combine it with other data that can be used, again, for other purposes that the people who gave their data to the website they have the relationship with, you know, weren't anticipating.
Thanks for that overview. There's a lot in there to react to, sort of, you know, the distinction between unauthorized scraping versus abusive unauthorized scraping, sort of what modes make, or what's enough to make adequate notice, clear and adequate notice that scraping is not allowed in under circumstances, or when it is or isn't. Some of what you said actually makes me think back to some of the old copyright debates around the DMCA. This sort of, you know, this sort of problem of once the website is rendered, it's out there, and that sort of reminds me of the analog gap, and that, you know, you can try to put as many DRM restrictions as you want on an audio file, but once you play it, the sound waves are generated, and there's only so much you can do to control that. Okay, there's a lot to react to, but maybe what I'll do is invite Hannah, and then Callie, if you want to come in and maybe say a little bit about, just build on that. What are some of the risks? What are some of the impacts to the ecosystem of users, industry, government, academy, for scraping?
Yeah, I mean, I think that Sarah's introduced this really well in representing online dating services. You know, we have a lot of similar issues that LinkedIn has. So if you think about online dating, we put a lot of personal information about ourselves into that online dating ecosystem. And to emphasize again, this isn't IP addresses and email addresses and that PII that is held behind our safe spaces, safe walls, but the information you put into your dating profile in order to be matched, in order to find that potential love interest, is quite personal still. And I think with online dating services, it's an interesting situation because it is a somewhat closed landscape in that many dating services are kind of semi-private ecosystems in which you have to join that dating service in order to see profiles. However, if you join that ecosystem, you can see many profiles. So there's that element of, to users, you know, how private is that data? But it's of absolute importance to dating services, of course, to create that relationship of trust between themselves and their users to share this like very personal part of their life. So the biggest impact that we, you know, of course, see is that loss of trust between our users, which is, you know, ourselves and our users, which is so essential to positive dating experiences, and of course to dating companies that are trying to deliver that. I think that we have a range of really negative impacts, and they may not be what you initially think about. You know, I think like LinkedIn for their professional lives, these are their romantic lives, which are something that they feel should be kept to themselves. But we've had instances where the entire websites have been copied, scraped and copied and put up elsewhere as completely fake dating websites. So huge loss of trust there for an individual who felt they were joining one specific dating service, gets put up elsewhere. Their own data is out there, their images. Dating services, of course, are highly based on images, and you can't hide your face in a dating profile. So that is then out there on another site you don't control. Huge impact for the company itself, because it's seen as though, you know, my members shared with me they got lots of messages saying I didn't agree to have my profile on this other website. It turned out it's a fake website. There's also the possibility we connect dating profiles with social media profiles, and if that data is scraped, it can be used to solicit on social media profiles. So you might look at a demographic on a dating service and use that to then solicit for other more illegal offerings, or to try and scam by using some of the information from that dating service to get into people's direct messages on a social media platform or other areas. So huge risk to the user from having their data scraped off a dating service with the information that is somewhat public. We have concerns around blackmail or other nefarious purposes. So if the data is scraped from a dating website that is for a niche interest, you might think about that, or in a country where that community of data is is a protected characteristic, but maybe that's illegal in that country. Huge ability for blackmail and used by bad actors. And we also need to think about victims of stalking or domestic abuse who have looked for a safe space to date again, and then if that information, that their personal data is taken from that dating website, could be used for causing harm. We also have the kind of broader web scraping of blogs and marketing materials. So a lot of dating services use marketing materials from their users. So success stories, you've probably all seen a dating success story, and those get scraped and copied onto other blogs, and the daters haven't given their permission for their images or their story to be used elsewhere. So they're all just examples of a breach of trust, in that dating users feel that their information is within one specific ecosystem of kind of exchange of data between daters. They know it's not completely private, but on that broader scale, they don't expect it to be out there. That's kind of an overview of where we are. I think we haven't come up with solutions yet. So I appreciate the first panel, made me think a lot. So I look forward to discussing later.
Callie?
Sure. To kind of jump in, I think when I look at potential harms to individuals, specifically when it comes to data scraping, I think there's two tiers of levels where harms occur. One is at the initial scraping. So when the data is taken, it removes the possibility of control or edits over that data. If I put up information on, say, LinkedIn or a dating site, I may want to change it in the future. I may decide that I overshared at first, and I don't want to have that out there anymore. I may decide that the way I typed something isn't totally accurate, and I want to adjust that a little bit. Once that information is scraped, you don't have the power to adjust it anymore, and so that's completely gone. And if I want to remove it, that's gone as well. Another factor is the intent behind sharing. You know, if I'm sharing information within, say, a dating site, I intend for that information to only be visible to other members of that site, and only for the purposes of, you know, trying to form a relationship. I don't intend for it to be spread to multiple other companies, put on multiple other sites, shared with multiple other people, or put into, say, a file on me that draws from multiple other sources and then gets much more granular information about me. And that leads to the second stage of harms, which is after the initial scraping. It's very easy for this information to be sold to data brokers, to be combined with a lot of other data sets. And then once that happens, there are inferences that can be drawn from large patterns of information. Algorithmic or AI-driven inference generation is very specific. Even if it's not always accurate, it still gets used very frequently. And that can be used for scoring or for results when you're going to do other things in your life, when you're applying for jobs, when you're applying for housing. So the scraping ends up causing some serious damage there when it leads to inferences or leads to profiles that can cause damage through bias or through improper use, improper conclusions that they've drawn. There's a lot of issues there. And then beyond the harm to individuals, which I think we always focus on because that's kind of my focus in general, there is real harm to the companies that are hosting this information and who have had their terms violated or have had their purposes violated. As mentioned before, real issues when it comes to trust of those websites, even if they've taken technical measures or put in place policy measures trying to prevent this exact scenario. And there's a problem down the line. If trust continues to erode, people won't use these sites. People won't share their information because they don't feel safe doing so. And in some ways that can kind of make this whole system defunct. And in another way, it can also be a real problem for people who need to use certain types of data scraping for their work. So journalists and researchers frequently will use data scraping in their processes, but those tend to have more barriers around them. They're for a specific purpose, they're for a public good, there are protections built in for how that information is used, so it tends to be a little more ethical. And that process is going to go away, again, entirely if data scraping keeps being misused by individuals and by companies for unapproved or unethical practices.
That's really interesting. And I think that calls to mind one of the things that I alluded to earlier, which is the difference between abusive unauthorized scraping and unauthorized scraping. So scraping that's maybe for the purposes of security research or news and journalism. And so Brandy, I wonder if you might talk a little bit, not only about the risks, which we've heard quite a bit about, the risks and problems that attend to data scraping, but maybe the possible benefits, or what are some of the things that we have to balance concerns about data misuse against, like these sorts of research projects?
Yeah, thank you so much, Tejas. And the discussion so far, really interesting to me. I think to just start, of course, platforms hold vast troves of data that can be incredibly impactful at documenting things that are of public interest. For example, documenting the spread of disinformation, documenting public health concerns and appropriate interventions. But I am sympathetic to the companies and what platforms are facing, whether it's ensuring compliance with data protection laws or protection of proprietary data and models. Probably many of you in the room and online saw that Meta was fined about $275 million by the Irish Data Protection Commission for violating Articles 25(1) and 2, which is essentially the portion of GDPR that says that anything you build should be data protection by design and by default. Now, as a researcher who has used the APIs and also explored use of scraping, this causes me a little bit of concern because the companies, I believe, will put in place more of these technical barriers for third parties to be able to scrape. And I completely understand why they're doing it. When you're implementing those technical barriers, however, it's not like the company can know whether or not that third party that's scraping is doing it for altruistic purposes or for malicious purposes. That'll come out later. In the last panel, I heard them discussing that maybe we should have some type of law at the federal level that defines scraping and sort of sets guardrails for what's appropriate or inappropriate. Also on that panel, and I'm an academic, we noted that not all research is good for society. It can be incredibly harmful, and that we tend to rely on these institutional review boards. And I would say of myself going through that process of having projects reviewed by institutional review boards, typically they've taken the stance that if any data is publicly available on a website, it's free reign. So I do think that there needs to be new training for institutional review boards to be able to better scope out what types of practices researchers should be engaging in. And then quickly, before I hand it off for the next question, I wanted to raise up two pieces of legislation. The European Union has been just moving forward at a lightning pace, I think, definitely in comparison to the United States, on pushing forward some more laws that will actually try to address some of this problem. So the European Union passed the Digital Services Act, which will create a mechanism for what they're calling vetted researchers to be able to gain access to platform data. And this is in collaboration with the platforms. The platforms will be able to push back and say, we don't want to share that data because there are personally identifiable information concerns. We don't feel it's compliant with GDPR, or it's proprietary data. We don't want to share it. But they're creating this mechanism. It's a great first step, but also as a researcher myself, the timeline for this process of becoming a vetted researcher, of coming up with your research question, your hypothesis, which is supposed to help identify systemic risks, identifying the data. This is a very, very, very long process and a high barrier to entry. Only a few researchers, I think, will be able to actually gain access to this data. And then quickly in the US, we have a similar bill that was proposed at the federal level and also in the California legislature called PATA, the Platform Accountability and Transparency Act, which would perform a very similar function in the US, with the NSF and the Federal Trade Commission serving as sort of vetters of the research and a data broker between researchers and the platforms. I also want to note quickly that in PATA, there is a protection for scraping. There's essentially like a shield for researchers who are using scraping to gain access to data, and flagging that, because in our discussion here, even though it's allowed, we need to be conscientious of what data researchers are pulling in, what they're doing with that data.
So if we have time, I would love to hear from everybody on sort of not how PATA is written, but how you think it ought to be written. So how would you design a sort of legislative approach that strikes the right balance? But before we get to that, actually, Brandy, I want to go back to something that you said and then ask you to respond and then maybe bring everybody else in too, which is, so one thing that you said that you found troubling was the way IRBs, institutional review boards, think about public data. And they say, like, look, if the data's on the website, it's public and you can access it. And Sarah and Hannah and Callie, you all sort of evinced some sort of discomfort with that, which is, well, look, like people should be able to go back and revisit their, like, edit their tweets if we ever get that edit button, or like fix their profiles, or change their pictures, and sort of have control over their online profile, their online destiny over time. And so I guess, the question I would ask is, how do we know then when online content, or when like something you post through a platform is sufficiently public such that it's okay to scrape versus when it's not, and who should say?
I'm shaking my head now. That's such a tough question, Tejas. I think, well, we have a proposed data protection law at the federal level, and California has the California Consumer Privacy Act and the California Privacy Rights Act. I will say that in the CCPA, there is a provision that you do not have to comply with your user requesting a data deletion if that data is necessary for research that serves the public interest. And I can feel like the collective cringe of everybody hearing this, because what is the public interest and what does this mean? And is this going to be scoped so broadly that any data will be maintained because it could potentially be used for public interest research? Yeah, so right now, essentially the companies and the researchers are deciding what data should be made available.
So Sarah, taking as given that your comments do not reflect the views of LinkedIn or the parent company, I'm interested in your thoughts, because I suspect you've spent a lot of time thinking about this question, which is, how do you know, like when is it okay to scrape, if ever?
I have thought about it a lot. I mean, look, this is why this issue is complicated and hard. But at the end of the day, and again, I'm speaking from my own personal perspective, but also just from the perspective of thinking about it when it relates to personal data as opposed to facts about whatever. I think that the user, the person whose data it is about, should have a say in how data is used and whether it can be scraped. Now, I don't know, maybe that means we need a setting, but I think, if we have we have a relationship, LinkedIn does, with our members, where we promise them we will only use their data that they give us in certain ways. And we lay all that out. We are obligated to them in that way. We are accountable. And ultimately, when people come and scrape without permission and use it for purposes other than that, like that relationship of accountability and trust doesn't exist with that third party. So for me, I just keep coming back to that. When it relates to personal data, I think it's important that the person gets to choose whether or not random company can access their data or not.
I mean, so that's interesting. It sounds like user control over personal data is important. But one thing that I think you said maybe a little bit quickly, and maybe I'll get into trouble, is that there's a distinction between personal data and facts. And I wonder how you would draw that distinction.
I just meant, that was probably just inartful phrasing. I meant data about people as opposed to data about things. Like, are we talking about flight schedules or, directions to a park, as opposed to like where a person works or what they look like or other personal information about them.
Got it. Okay. Hannah and Callie, same question, but maybe we'll go in the opposite order this time. Callie first and then Hannah.
With the caveat that I am very much a tech lawyer and not technical. Like I don't have tech knowledge. I think it would be interesting to see if there were some way to essentially lock down sites to the point where scraping couldn't really happen unless users got a prompt for unless people that wanted to scrape had to essentially submit a request to scrape and then be approved. And in that way, you could screen a lot better. So you could make sure the intent behind scraping is something that is permissible or ethical. So in those cases, you could do something where journalists or researchers maybe are permitted access in ways that other companies aren't. I don't know if it's technologically possible to do that, but you mentioned this is idealistic, so I'm throwing that in there. In general, if we were looking at a law that had to do with scraping, I would err on the side of altogether banning rather than allowing if we can't find a way to make that nuance happen. If we can, I think that there are ways where we could propose that APIs be set up on sites that allow for not scraping, but basically an alternative that accomplishes some of the same goals, but in a much more controlled way. We could possibly go by intent. The GDPR in some ways goes by what the purpose of the processing is, what the purpose of the collection is. So we could try to make a law that says scraping is permissible for these processing purposes. That still wouldn't necessarily technologically stop bad actors from scraping, but it would mean that if they did and they couldn't demonstrate that there was a valid purpose behind it, if they got caught, you could go after them for it. I don't know if there's a perfect solution for data scraping, but I think those are approaches that could maybe start to get at the heart of the issue, which seems to be just people misusing this process.
Can I quickly jump in on this? Callie, that's an excellent point. But I disagree. I don't think that we should totally ban scraping because of the great benefits, not only for research, but also for like building up new companies, and companies themselves rely on scraping like their own other pages of things that they've developed. So it's just too valuable of a mechanism. And then the technical mechanisms, like, can you actually block it? I think, unfortunately, it would probably make any web page completely unusable because of like, there'd be like a CAPTCHA every time you scroll down the screen long enough, and you'd have to put that in. But yeah, I'll leave it there. I have a couple other points, but Sarah, I see you unmuted, so I'll let you go.
Oh, no, I agree with you. The technical feasibility is what I was referring to, at the start, that there's just no technical way to prevent it in every instance that wouldn't make the site, wouldn't make the site unfriendly to use.
I want to make sure we get to Hannah, but then I want to build on exactly that question.
I'll be brief. I think I was just going to talk about, in the context of what is on the internet forever, dating profiles are absolutely not meant to be on the internet forever. That's not the intention when someone joins a dating service. It is for that period at which they are looking for a relationship, and users do usually delete their profiles when they find that relationship. So when any of that data is scraped and is elsewhere, that is in direct contradiction to the intention behind dating services and to the terms and conditions of dating services. We've mentioned GDPR. There's the right to be forgotten in GDPR countries as well. So there's an assumption with people in those jurisdictions that they can completely be forgotten from their dating profiles. However, we have the interesting situation in dating, and that profiles may be deleted. However, a certain amount of data is kept for at least 2 years because of the potential, and it'll be the same for any social platform, of harm having been committed on those platforms. That data and that information has to be kept for a certain amount of time in case there is a situation in which the police need access to that data if a case comes forward. So we are already kind of grappling with that. Is this data staying for a certain period of time, and then it's kept in a different way for another period of time? And if there is concern about a profile or an interaction by the dating service, it might be kept for an even longer period of time in an encrypted manner, but in a way that it could be called upon if it is required in terms of dealing with harm. So we've been thinking about this in other areas, and I think it would be useful to use that in terms of this conversation.
Thanks. That's interesting. I'm trying to decide what direction to go in. I'm gonna go back to the question of sort of implementing technical protections and the sort of balance and trade-off between the user experience and protecting data. And I guess the underlying question is, if data is public or could be public, right, whether it ought to be public or not, one question we might ask is how we should protect it. And so you could imagine a couple things, right? You could imagine a more robust set of technical measures that, as you've suggested, have effects on the user experience, or you could imagine a more robust legal regime. And so the general question is, how should we try to protect the data? Protect data against unauthorized or problematic abusive scraping. And the more specific question is, if you could only choose one, technical measures or legal measures, which approach do you think is more effective, however you want to define the word effective? And Callie, I want to start with you because I think you wanted to say something on this, and we'll go to Sarah.
No, I was giggling a little bit because when it comes to the battle between technology and law, I think it kind of comes down to what you're most familiar with. I would love for technology to be the solution. I don't know it well enough to know if that's even possible. So I would probably err on the side of using a law for it because that's what I know, but I don't necessarily think that that's always the best. I don't necessarily know that they always get enforced the way they're supposed to. And we've run into the problem multiple times where the law is just not agile enough to adapt for how fast technology changes. So that's what I know, that's what I would go with. But if technology has a better or quicker or more adaptable solution, that would be great.
Sarah?
Should I jump in? Yeah.
Yeah.
So I'm also a lawyer, but I have a different viewpoint. I don't think that one should have to choose. I think that fighting unauthorized scraping requires both legal and technical steps. But if I had to pick one, I would pick technical steps every time because it's technical measures that are scalable. LinkedIn, like speaking from the legal arm of, protection, and in my experience with that, you can file lawsuits. That's something that LinkedIn has done a number of times over the years with success. But there are many, many, many more scrapers than there are time and resources to file lawsuits. We've also sent letters, explaining to people, you can't do this. This is why. That can be highly effective. But at the end of the day, like, you need technical measures to stop something at scale. Whether that's the detection technical measures that I referenced earlier. Repeat abusers might need to be restricted from using the platform entirely. It's not scalable to sue every violator unless I get a much bigger team.
Hannah or Brandy?
I have something. I actually think that it's both technical and law. And, Lawrence Lessig, very famous lawyer, said once, code is law. To me, the technical implementation is informed by the law. The law will shape those technical measures, and technical measures as they are developed over time will help to shape the legal or regulatory requirements that are made available. So I think it's actually both in collaboration directly with each other. And one other thing I want to bring up is that, okay, let's say a third party does scrape a lot of data. And we see this right now with these very large models, multi-purpose, general purpose AI models, scraping large amounts of public data. And the Federal Trade Commission, as one remedy, is starting to say, maybe there should be this algorithmic disgorgement. So if you are making, you're using this data, this ill-gotten data, you should have to purge it out if it was found to be collected in a way that did not adhere with any legal requirements. However, though, implementing that in practice is much more difficult. These companies right now are pretty successfully able to push back and say that it's nearly impossible for them to remove that data, except we've seen some examples like with Clearview AI in the Illinois biometric law where they had to remove any individual's data from Illinois. But I would say that's definitely a space to look at that's at that direct intersection of a regulatory requirement and a technical process.
And yeah, just to say very briefly on that topic, I think that having the legal, and I'm definitely not a lawyer, having the legal framework would be useful, but only if there's a regulatory regime that comes along with it, because the majority of companies that are medium to small size would not even be able to access any sort of litigation. So unless there's a third party regulator trying to create processes in which you can deal with this happening, we're dealing with this in the UK at the moment with the online safety bill. You know, the legal element only means so much if there's not a regulator. So if there is a regulator, then the technological solutions become available for all size companies, not just those who can develop their own technology. So it kind of creates its own ecosystem around delivering the outcomes of that legislation.
But so on that, sort of on exactly the sort of, you know, when a regulator can take action or when a lawsuit might be filed or the sorts of technical measures that you might want to implement. So I should note we're actually getting into our last 5 to 10 minutes here. So if you're in the audience and you have a question, please put it into the Q&A. There are a few questions that are already in there. And so actually the next question I have is one of these, which is, the question asks exactly sort of, are there ways to detect when scraping is happening? And is that useful to know? And so there are ways to detect when scraping is happening. And I guess, you know, the question I would ask you is sort of, maybe talk a little bit about how you detect scraping. I don't want you to give anything away that you can't give away, but sort of how you detect it. And what sorts of information would regulators or enforcers need to have if we were to imagine a sort of a public legal regime around unauthorized access to web data? Hannah, do you want to start?
So a great question. I'm not going to be able, as I'm not a technologist, I represent my broader members. I'm not going to be very good at answering how do we detect if web scraping is happening. I'm still learning about web scraping as well. So I'll just say, I know it is possible in some circumstances and not in some circumstances. And Sarah, you can probably answer this question much better than I. But in terms of a regulatory regime, I think it's having a mechanism in which small and medium-sized businesses are able to, in the first instance, report when this is happening and having some sort of centralized database space in which it can be recorded and, I guess, acknowledged that this is happening in all these spaces and this is how it's happening. We've dealt with similar in terms of fraud. I apologize, I keep bringing in examples from other areas that are issues, but we've moved further with fraud in that there's a conversation going on between all the parties who are being impacted by this, and we're not at that place, I wouldn't say, from our perspective with web scraping yet. So that would be the first instance the regulator would be able to create a place where this information is shared, this data is collected, and then those with more technical knowledge in terms of regulation could say this is how we could move forward. That's a poor answer, but my area of expertise only goes that far. So I'll let Sarah give more.
Sure. Well, with the caveat that I too am not an engineer, I would say, you know, broadly, companies that are concerned with, you know, scraping at scale on their platforms would typically put in place several layers of technical barriers to try to thwart automated activity, and that would include things like rate limiting, machine learning models that detect patterns in visits to the website that are abnormal and don't seem human. You know, scrapers, there was reference to this, I think, in the first panel. Scrapers are get more and more sophisticated, more and more advanced at faking being a real person, you know, through a variety of mechanisms. And so basically just having a machine learning model that continues to get better as scrapers get better to detect and, again, you know, block or thwart some of that activity.
Brandy?
I agree with what Sarah's saying. Yeah, there's these, machine learning models that can identify this and, raise a flag for the companies to intervene. I think one thing that we haven't really touched on that we should is that the companies, they do see these third-party scrapers, and I do commend them that sometimes they will reach out to those researchers. So if they know it's a researcher scraping this data and say, hey, we noticed that, you've been scraping data, and actually start to form a partnership or a relationship with them. And I think that's incredibly important. And I think there's often this perception of an adversarial relationship between researchers and the platforms, but I would like to see that, dissipate a little bit, because the companies and the platforms, if they work with researchers, that research could be used to improve their products and services. I know that there's this fear that the research insights might be used and shared with, state legislatures or the federal government, and then there might be laws based off of that research. But imagine those companies being beholden to a law drafted on research that they had no play in and that they didn't inform. And what if it's completely incorrect? Now they're beholden to some, overly burdensome law that they have to implement. So instead, I think it's really important that we continue to foster collaboration between the stakeholders to be able to share data in ways that supports all of the great benefits that we can glean from platform data.
And Callie.
I don't know that I have a ton to add to this. I think everyone else is more knowledgeable about how exactly you can detect scraping and that coming up. I will say that there have been some really interesting court cases lately addressing what happens when scraping has happened kind of at large and en masse and formed its own databases. Clearview AI is the example that always comes to mind there. And I think it's interesting that there now not only is technology that can apparently determine when a site is actively being scraped, but also there are a whole lot of online internet sleuths that are looking after their own privacy or other people's privacy and will send up flags when they see that there's information that clearly has been copied and taken from other sources. So that's kind of an additional component of this situation in tracking scraping practices.
I'd like to add something quickly to that. Callie, I'm really happy that you brought up Clearview AI because they've scraped over 20 billion facial images. And of course, this violates GDPR, and you see that they are getting fined. So France and Greece have already fined them, but essentially it appears that Clearview AI is just incorporating these fines as part of the cost of doing business, right? They're so big in the space and they have so much money that them paying a $20 million fine seems like it's nothing. So I think that's something we have to think about when we're talking about remedies. If we're going to issue fines, I think we'd better make sure that the fines are steep enough to really be a real slap on the wrist of these companies. Otherwise, they're just going to set aside that money to pay the fine so they can keep operating.
Okay, I think we are technically out of time because the panel's supposed to go till 3:50, but I guess I want to give each of you a last word, and maybe I'll ask you to answer a specific question, which is, if there's only one thing that you wanted everybody to understand about data scraping, and I mean everybody, not just lawyers in the room, but users, what's the one thing the one message you would want to convey to everyone? And I guess we'll go in the order we started in. So Sarah, Hannah, Callie, and then Brandon.
If I'm allowed to only say one thing, I would probably still go with it's not a data breach.
Okay, it's not a data breach. Hannah.
Similar to what I was thinking, but that it's an area that needs collaboration. We need to talk about it, share, and find solutions together.
Not a data breach in need of multi-stakeholder solutions. Callie.
I think it's a really good prompt for talking about what public data can be used for and what the intent is behind it. I don't have a super succinct summary of that, but I think it's an important conversation that we've been having in the privacy community, and it's only going to become a bigger topic of conversation.
Okay, so not a data breach, but rather a forum for a multi-stakeholder conversation to talk about norms around what data is public and private. Brandy, I'm trying to put it together.
I will say I agree with everything everyone before me has said, but I would also just warn that any technical or legal or governance mechanism put in place that we think really carefully about, okay, if we're trying to mitigate a harmful data scraping, are we also inadvertently harming beneficial data scraping that really benefits society, and really balancing the benefits and the risks?
Not a data breach. Rather, we should think about the different stakeholders who have different equities, both pro and con in data scraping, so that we can come up with norms about what data is public and private. Thank you all so much for a really fun conversation. I really appreciate it. And thanks again to the audience. This was a lot of fun.
This panel is entitled The Impact of Unauthorized Scraping on Industry. Our moderator is Hemu Nagam. He's a partner here at Venable LLP. Mike Clark, the Director of Product Management for Privacy Infrastructure at Meta, is one of our panelists. Veronica Torres, who's the Worldwide Privacy and Regulatory Counsel at Jumio Corporation, is with us as well. And Doug Hudson, who's the Vice President and Deputy General Counsel at Etsy, has joined us today as well. Thank you.
Just introduce myself. My name is Hemu Nagam. I'm a partner, as Sarah just said, at Venable LLP, but I've also been working in the privacy, safety, security space now for 30-something years. I think 31 years, just to be precise in case, so that people don't think it's 39 years. So 31 years, and a lot of the work I've done has actually been. You're gonna turn your switch on. Oh, is that what it is? Oh, didn't even know about the switch. How about now? Am I real? Am I alive? So I've been working in the privacy, safety, security space for 31 years. One of the areas I focused on was actually online crimes, and then going after movie pirates in the online space, worked inside of Microsoft, News Corp, Fox, and MySpace. And what, especially at a time when MySpace was hitting the world with tons of data out there, and people were starting to realize the value of the data. We have with us a pretty distinguished panel here. And I will say first, I want to point out Veronica's title. I have not seen a cooler title, Worldwide Privacy and Regulatory Council. But why don't we take a minute for each of you to introduce yourselves? And Mike, you want to start?
Sure. I'm live. I didn't have to turn on the switch. Mike Clark, I am a product director at Meta. Most of my career, I've been either an engineer or built startups or worked at Photobucket and MySpace and some online security spaces as well. At Meta, I specifically work on our privacy infrastructure space, which one of the things that we do is build anti-scraping both technology in addition to investigate and enforce and take steps against anti-scraping, and how we deal with third-party data and data lifecycle management and a whole bunch of fun stuff.
I am Veronica Torres. I am Worldwide Privacy and Regulatory Counsel, as well as Data Protection Officer for Jumio. I'm also from Miami, so I had a lot of friends make the Miss Worldwide jokes through Pitbull. So that just means, the title just means that I run the privacy program and I'm responsible for our global operations. It's been great. I started my privacy career at Nielsen way back when in law school under Elise Burkauer, actually. It was a great opportunity, jumped straight into privacy. I worked for Sony. My previous position was at ComScore, which is Nielsen's biggest competitor, which was a nice little full cycle moment in my career. And I was chief privacy officer there. So working on a lot of different issues with web scraping as to whether we're allowed to, whether people are scraping our websites, and what data is out there as well.
I'm Doug Hudson. I'm DGC Global Regulatory at Etsy, handling security, privacy, and other regulatory issues that are just kind of exploding worldwide. Before that, I spent some time at Twitter, and before that at Google, handling a kind of a diversity of these issues. And over the last decade, just privacy and security have become more and more of the focus of my practice. I think while I'm here completely on my own behalf and not on the behalf of Etsy, one thing I've noted is, and other panelists have mentioned, the impact not just on platforms, but on end users, that both for their professional lives and personal lives, malicious scraping can impact their livelihood, can impact their safety. And I think that's part of hopefully some of the points we can address in this panel.
So actually, that brings us to a wonderful segue to the question. Stu this morning or this afternoon when we started said that the Mitigating Unauthorized Scraping Alliance, now I think it's going to be officially known as MUSA. When it was started, it was because it was ripe for a conversation, a public dialogue. But that happened because there has been an increase in unauthorized scraping over the past several years, if not the past decade. So my first question goes to Veronica, which is, why do you think that is?
Because it's easier is the answer. 10 years ago, it wasn't as easy. It took a lot of effort, both from the unauthorized scraper side or the public research side. It took a lot of effort to figure out, how do we get this data? Where is it? What's valuable? You're looking at code that has tons of information that's not structured. And so you're having to pull out your own data. Nowadays, it's as easy as you were saying, Mike, that like you can go onto AWS and there are tools for scraping and there are tools for things online. It's very similar. Coben and someone else earlier spoke to, ChatGPT, OpenAI, types of tools like that are now with the common man and common woman. And they're in this place now that you can just access them instead of having to develop them on your own. So I think that's probably why it's more common.
Mike, you've been in this industry for a while, as you said.
I'm a recovering scraper. I think 12 years ago I scraped, but it would have been MUSA. It was authorized scraping. Built a startup in child protection for helping identify public content that could potentially create harm to your child, your family. And it was hard, like having to build and integrate with 180 sites and how to integrate that data and get authorization was a lot of heavy lifting that today, without authorization, would be a lot easier. But I think there was some fundamental shifts that happened within the last 10 years. And I think one of them has to do with, as GDPR came to be, as companies looked at the APIs that they started putting out in the late 2000s, there's a lot of data attached to these APIs, and companies built, whether it was in advertising, whether it was in surveillance, whether it was in a variety of different spaces, companies built entire businesses, got public funding and virtual and VC funding around this space. As GDPR came to be, as Cambridge Analytica happened, so came this pressure to cut off the data that was going out through these APIs. But the economic incentive to have this data and use this data and sell this data and the marketplaces that have been built didn't change overnight. And so overnight supply goes away, but demand was on an increasing trajectory. And that's why we've seen, or that's at least for me, why I've observed both for Meta, for the industry, like that's where I really observe a lot of this coming from, is that by cutting off the supply, none of us did anything to address it. And I think it's also where we're all being held accountable for still providing the supply of data, which the supply of data is what we all require in order for our products to even work or function. And just that's a really hard spot to be in. I do have to say, like, if we treat this like therapy for a moment, we're not alone. Like, it's really great to hear like people thinking about it, both people that are scrapers, people that are representing scrapers, people that have companies and platforms. We're all in the same boat, and that is one nice thing about today as well.
And so let me ask, and this is going to be a question for all of you, so get ready. But let me start with Doug. One of the biggest things every company faces is issues in security, issues in privacy, issues in safety. So when you put that in context, how big is this problem versus the world of problems out there?
Yeah, I mean, when you think about scraping, it kind of falls in three groups. You've got malicious bad actor scraping. You've got, which we started talking about, then you've got the competitive / consumer scraping. And then at the bottom, you have like researchers who need data. For the reasons that Mike put forward, I think the risk for malicious scraping has gone up by orders of magnitude. You press a button and you can fire something up with AWS. You're hidden behind some AWS IP blocks, maybe Cloudflare behind that, and then you're in some other country. So you can create 1 million web pages based on stolen data in a minute. This is impossible for any one platform, no matter how big or small, to really counter on their own. You're not going to be able to send takedowns on that scale. And that content may not be in the content, may be your user's content. So it's not going to be an old-fashioned DMCA takedown. You can go to a Cloudflare, but the norms aren't there. It's like, oh, this is a phishing site, please remove it. What do you do when there's 100,000 of them? So the malicious issue, I think, is across industries and across platforms, one where the seriousness of it is kind of escalating. For the competitive side, I think that's an area where we have to be awfully careful about how we implement regulation. There are side effects that may be unintended, some of which were talked about in the prior panel, but I think are worth exploring. But I think that may come in with a later question. So
Veronica, what's your take on this? Because you're worldwide, as you said, as we all said now 3 times at Jumio. But so where do you put this in the context of all the other challenges that you face?
I think it depends on your industry and what your company does. You know, we don't have a public platform for individuals. There's no publicly available public or personal information on our websites other than contact info for me. So this is, you know, that's the information people are going to be scraping from us, but it's more that competitive side and that competitive information, what they're doing with it. And so I think it really depends on what your you know, threat vectors are, what you're looking at to prevent, and then implementing programs that address those issues. It's really it varies across every industry, I think.
Mike, you're the opposite. There is public information on Meta.
Well, I think what was interesting is you use some other examples like privacy and security and other things that have very clear frameworks. There's academic frameworks. There are, you know, I think I drove by 7 buildings along the Dulles Tollway that I recognized as, you know, MITRE and other companies that have built their entire existence around the definition of frameworks and enforcing those. It doesn't exist for scraping. I think as I've heard the conversations today, like the one thing that came out is there've been 12 speakers so far, and there's 12 different definitions of what scraping is. I think there's the impression that it's just websites, and that's what it started off as, but now it's first-party APIs. It's the API intended only for my application or my website to talk to my servers, and it's not that. And that's what makes this extra hard. It's what adds this additional complexity to everything that we're talking about here today and throughout it, because if none of us have the same definition, it means that when the statement earlier, scraping isn't a data breach. And, you know, as a platform, as a consumer, when you see a large data set, like it's the first thing that comes to mind because it's what we've been trained for the last 15 years, and it's not what's actually there. So you two covered most of the topics, but just adding that on top of that, that's part of what makes this so difficult.
And so, I mean, I think I'm hearing, and I've been hearing all morning, I keep saying morning, because I'm in LA time still, is that this is a growing problem. I mean, I think a lot of times in the online world, a lot of problems grow over time. This one is now ripe for real public dialogue that we're kind of having right now. The question that also raises, why do threat actors scrape? And I know some people have touched on it, but from starting with you, Mike, since you're closest to me, why do they do that?
Well, I mean, I think one of it goes back to the economic side. Like there are commercial businesses to be built around this data, and that's part of it. I think there are, you know, there is surveillance. There's a wide variety. I think, you know, it's, you know, examples that are out there publicly, that examples that we've shared and talked about of countries, of nation states building platforms to try and scrape data of citizens from adjacent countries and use for a tactical advantage. It is a wide variety. It's things that, you know, as all of our systems converge into like being able to use many points of data to make decisions, as we're talking about with OpenAI and ChatGPT today. As we watch and observe, the ability to look at patterns of things that are happening, make predictions in markets, or the claims of surveillance companies to make what kinds of crimes are people going to commit? The kinds of things that used to be in sci-fi movies 15 years ago, we now see companies making claims about. But this is what's driving this market to scrape it. We also have researchers, and we have a bunch of other reasons that are driving it as well. But it's economics that are driving a lot of it.
So, Doug or Veronica, do you want to add?
I just think, you have, because we talk about unauthorized scraping, I think it sounds very negative and it sounds very like, oh, you're not supposed to do it. But there are very, earlier panelists have talked about the public good, scientific research. Just because it's unauthorized doesn't mean there is not a purpose to the scraping. And so, Doug here had your tiers. You have your malicious, so trying to create false competitive websites, phishing, things like that to access data. You have your competitive nature, building products either for a good because you think that there is a place in the marketplace for another product that utilizes this because you want to be competitive, maybe a little maliciously towards other big box retailers, or the public good side. So it's a very much, just because it's unauthorized doesn't mean that there's not a purpose to it. And threat actors have a variety of reasons for doing it. So it's you really have to take a look at what the result of the scraping is, not just the scraping.
And you were nodding your head so many times, I have to say, what do you have to add to that?
So this kind of goes back to what everyone here has been saying. For the malicious folks, to fire something up is incredibly cheap and incredibly quick. So until things change, where the cost of committing those bad acts is more than what they get from phishing people and fake transactions and selling people's personal information. And we were able to create friction from technical, legal, and cooperation with governments and via industry norms. It's not going to change. That is one area for the last panel. I agree. Technical changes have to come first because on the malicious scale, it's the only way in the short term you're going to increase costs for what's increasingly becoming part of multinational crime syndicate stuff, not just somebody just sitting up a site. You're seeing things done at scale to the largest platforms that are out there sometimes, and we need a solution. For the other two areas, like I said, I think the solutions are different, and we really have to be careful of trying to fit a single piece of legislation to solve all three problems, because you're going to get lots of unintended side effects.
Mike?
I will just add back into that though. I think our dependency or kind of reliance on just technical solutions, from what I've observed, is too early. I think you can depend on technical solutions when there's very clear frameworks and there's things that we can all align on where purpose comes from, where consent comes from, how the purpose of research may have a very high value to society, but to me as a consumer be very risky. And looking at the dating examples, looking at some of the other examples out there, it's without that connection from who originated the data and who controls and owns the data to the platform is a pretty tough spot to be. And I think there's also this misconception that technology scales, that I think we all want to depend on it. We want to depend upon rate limits, but rate limits don't actually make determinations on scraping. It's merely increasing the cost of acquisition of data. I think when we look at bot detection, it's very, very nascent, because the same model used to train what would look like malicious activity is the same model that the other person can run to actually make it look more like a human. And so there isn't a gap between those. And I think we've talked about in some of our posts the billions of transactions, many billions of transactions that we block every day. And it is because it's adversarial, because it's economic, people are going to change, and technology can't keep up with that change. And so changing that we have an expectation of consequences, whether that's through regulation, whether that's through litigation, whether that's through consumer response, and activities is really a challenge. I, as a consumer, can't go affect Clearview AI unless I live in specific jurisdictions that action has been taken against them. And so it really leaves me powerless on how my face is being used by them.
So, that raises actually another area which is even more interesting. That we already have challenges in technical implementation. We have challenges in understanding what type of data it is, the purpose of the data. But often we hear people saying, oh, it's a privacy issue. Oh, it's another security breach. What is the reaction of you all when it comes to that? Whoever wants to start first. Is it a security breach? Why not? Is it a privacy breach? Why or why not? Or is it something else?
From my perspective, I start, okay, who let this happen? And not from an accusation standpoint, but if someone is scraping, I'm wondering how and what they're able to access. And so from the first start is what's out there on our websites, what's out there on our properties that others can gain access to, and then how can we move forward to prevent that access going forward? Are there any legal ramifications we can, or legal things we can take that would prevent this party or parties in the future from doing that? But it's first an internal inventory of what we're doing, what data is there, whether it's competitive data, whether it's personal data, looking at how that is architected, how it's structured, so that our security teams can come in and say, oh, well, that S3 bucket didn't have the right access controls and it was sitting in an open space for everybody to access. Or say, no, we had everything in place, but it was just, luck of the draw at this point and the technology is too advanced to fix it. So I'd start with a personal inventory of what that looks like and then assess from there. Because it's not always straight to, this is the worst thing that has happened to us in the past week. There's usually more fires than that. So it's really assessing in the context of what data is actually being scraped.
And I think reading between what you just said, you're almost saying it was publicly open, therefore it's not a security breach. Mike, do you have a reaction to that?
I think in some of those cases, I'll date myself in tech by, I think working on sites that I did at the time and projects that I did, when security was coming to be an issue, it was, very obvious that somebody was within a boundary that they weren't supposed to be, which started from like a connectivity layer. Like this person can actually touch a system that they shouldn't have been able to from a connectivity to the internet, and firewalls and other things matured. But it's really taken 15, 20 years for security to mature to a space that it made sense. There are very strongly developed frameworks. There's all these things that exist where we all have a clear understanding of what is a security violation and what is not. Privacy, on the other hand, when it came, privacy is ultimately the expression of a consumer's control over their content. Who should see this content? Who should have control of my data? How should it be processed? And that with, MySpace, and you must cause that, and PhotoBucket, YouTube, and Flickr, and all the sites that came out about that same time, really helped establish some of the early privacy foundations. And we've taken what security took 20 years to mature, and it took privacy, another 10 years to mature to GDPR and other things that are governing this expression. There's very clear frameworks around privacy. When we look at scraping, I think you look at scraping, you look at inauthentic behavior, and you look at a series of this new problem space. We're in this third generation of problem that is, it's lacking in those entire frameworks. It's built on a per company basis. It's defined on a per company policy perspective. I'm really glad that MUSA is here, that we're starting to kick off these conversations on how do we talk about these things as an industry and not just as an individual company's definition of what this is, which is part of where litigation has been so complex. It's part of where enforcement has been so complex. It's part of why the engagements with the academic community is extremely complex in getting to that. And so when I look at these examples that we're talking about, it is this new class of problem. It's not a privacy problem. It's not a security problem. It's not a data breach in the definition of what these are. But if we don't address it, we as platforms and we as consumers both lose.
And to clarify, it might not be a violation of that actor's there might not be a violation from that actor that's not authorized scraping if that's open, but it's still a violation internally of policies and controls, maybe even contractual issues. If your privacy notice says certain things about their security levels. So there's still a, I don't use the word breach, but an incident that we need to address. It's just not necessarily something that could be actionable from an external perspective.
Doug?
I mean, practically they're different, but keep in mind some jurisdictions have a very broad definition of unauthorized access to data, even if nothing's done with it. So I know some folks like to use the same internal incident process because they're different, but it's like a Venn diagram. Each one is unique. But given how broad privacy law is, you can't just assume they're completely detached from each other.
Well, so right now we're talking about stopping access, right, or data. How about the opposite? The need for data, I think everybody in the other panels recognized, especially from a research community, is growing. And given that it's growing, how do we handle that need against what's happening on the other side, which is the unauthorized scraping, and how do you prevent it? So where do you draw that balance? I don't know, Doug or Veronica, do you want to start?
I mean, I feel like this goes to kind of the three caveats I wanted to mention. The first being, if this is interpreted too strictly, I think Timothy was going down this route earlier, you run the risk that the large platforms are consuming data from all sorts of third-party sites too. And let's say a regulator finds that the users' consent didn't cover what was being done, and the users didn't give consent for something, and there were technical controls sending that consent, but it's not enough. Well, is that a CFAA violation? Second thing to think about is the risk that an incorrectly created regulatory framework for scraping could inadvertently reinforce kind of data megaliths or monoliths. This happened a little bit with GDPR, and it came up in the last panel where unintentionally, and I don't ascribe any ill will to folks at Meta or Google, whoever, but unintentionally a side effect of GDPR is it became very many ways a one-way sieve, and maybe that impacted how people responded technologically, if they could legally. And in Europe, it was such a severe thing that you're seeing follow-up legislation in both the Digital Services Act, but also the Digital Markets Act, which will require express two-way sharing of certain types of competitive data back to other platforms. And the third is about privacy, and this goes back to the researchers in particular, and ownership of data. Users should own their own data. This is basis for GDPR. Weaker a little bit under CCPA, weaker still under like the new Indian privacy law. But it's not a perfect model here. So let's say you had a social media network, and suddenly a lot of users wanted to move their stuff to a new social media network. So there's a tool. Each user goes in and scrapes their entire timeline to go to the new tool. It's a violation of the terms of service. The platform puts tools in place tooling to stop it. Are all those users now violating CFAA? It seems so in competition with the other. Is a researcher who's doing the same thing to try to vet someone's policy statements on what their platform is doing. Are they violating CFAA if they do the same thing as the users are doing? This is why it needs caution. It needs not just a one-size-fits-all regulatory solution for scraping.
Veronica, let me add something, unless you want to respond.
I'm just trying to secure my job security for the rest of my life. You need more privacy people in the companies, in the startups, in public research, because privacy professionals sit at such a great place. Oftentimes I've found in speaking to peers and colleagues, they're probably the only one who speaks to legal and the engineering teams at the same time on a daily basis. They're the only ones talking to security teams on one side and also know what marketing is doing. It's a nice place to sit. And so you need those people. We talk about regulations, we talk about enforcement. How do we do this from a policy and framework perspective? But you also need people at the table saying, should we? Like, is that the way? Like, you need people both on the side of protecting your data. So you need the Sarahs of the world sitting inside the company saying this, we need more security controls, we need better terms, we need better contractual provisions. But you also need the people who are doing the product reviews and doing the, hey, do you think that we should create our entire company on data that we are just out there like with a net trying to grab? You need those people having those conversations on the ground and top of the regulations.
I'm starting to see a trend here. LinkedIn asked for more headcount. Jumio's asking for more headcount. But that actually brings me to another area that does require more headcount, I think, from just past experience. How is the industry even fighting unauthorized scraping? And I don't know, Mike, you want to start? Or
Still trying to define what it is, first of all. All the lawyers have job security. Part of it is defining what it is, and then it's deciding what are the things that we're actually trying to mitigate. Are we trying to, there are certain platforms, Twitter, for instance, sells its data, and so their reasons for mitigating scraping are because it directly goes against like part of what their market is in selling data. For us, it's around commitments that we've made publicly and living up to those commitments. For Etsy, it might be IP protection and copyright protection on behalf of the people that are actually selling products on the platform. And so there's a myriad of different incentives that are driving what we actually need to put in place as technical mitigations. And so I'll answer the question in two parts. I think what I've started to witness from managed service platforms, hosting companies and other things, they're starting to build in differentiators around bot detection, around security protections, around looking for patterns of what's actually happening in the activity, which I think is phenomenal. Because I think one of the concerns that I had as I delved into this space a few years ago, like to just focus on scraping, was, is this only going to be a thing that companies that have gotten to a certain point or publicly traded can solve? And what I'm really happy to see is this is something that like we're getting the technical foundations in place for companies to be able to solve it of all sizes. But we need to help them put teeth in the ability to enforce, because I think that is, what Sarah called out with HiQ and what's been called out in other cases, and even the Van Buren case that's been talked about a number of times here is, there's a ton of headwinds in trying to actually enforce and make sure that what you go enforce can be successful, but that you're also enforcing against the right things, and that's really hard. So hope I answered the question and just babbled.
So are there also technical things that people are doing that you're?
I mean, I think like talking to them, like rate limits and bot detection are a couple of them. I think starting to build new models of how I look at my own systems, not just through a security lens, but through a scraping lens, and using some of the things that we've learned in privacy and security and starting to tackle in scraping, having scraping teams that are dedicated on it as a problem space. The only way to solve scraping is to turn off the product. And we can't do that. For us, we have to have the data in the product for consumers to want to work with it, and for the company to even function, whether that's Facebook or Instagram. And so it's finding the right balance on controls. It's forcing some pages to be logged in that may have been logged out before. It's being really intelligent about product design, around policy, around everything that we do.
And Veronica, you want to talk about some of the enforcement things you've used in the past that may have worked? No? Okay. All right, so Doug, I'm just kidding.
I mean, takedowns can work to a certain point, but if it's the end user's content, it's a little harder. I think three things that work really well are: one, cross-functional working groups internally, like you were mentioning. When you're in the privacy and security side, you're dealing with everyone. So you're in a unique place to bring together a consensus, see what investment level can we do to fight this cross-industry. And then, to figure out best practices, to figure out what we can do and what works and what doesn't, when essentially just like intrusions and everything, it's a constant battle between one side and the other. And then finally, you know, we need help from enforcement. There needs to be a clearinghouse or some sort of support in law enforcement, because any one incident is probably not big enough to get their attention, but the scale it's happening at is enough that some sort of enforcement and regulatory kind of cross-functional effort, I think, would help, especially with the malicious actors that are causing a lot of harm.
Have any of you dealt with just sending out takedown notices, and what kind of response do you get when you do that?
Not a score we'd release publicly ever, but I think what I would share as an observation is I think a number of years ago when we started to do this and in recognizing it as a problem and seeing it as a growing trend, there was a lot of middle fingers and other things coming back to people responding to takedown notices or actions taken. And I think HiQ, as Supreme Court put down their ruling, we watched and observed professional scrapers that have services. If you just look at the tone of their marketing, change significantly. And I think what we've seen is there have been more and more successes, and I think the response rate has improved. I think also all the companies, I think all of us and everybody that's been a part of this today has gotten better at building the technical solutions that take the simplest type of scraping offline. And it's the more sophisticated actors that are left, which have more at stake. And so.
Anybody want to add to that, or I can turn to the next question, which really is focused around regulators, right? Are referrals to regulators an area that should be explored? Is it successful? What are some of the roadblocks that you may have seen or expect to see? Referring, say, threat actors.
I think I think it would be, I think the benefits of the investment of time by industry and regulators would be kind of a benefit plus. That time is worth the energy put into it. Along with some reinforcing some norms and industry practices, be it about the way takedowns are handled, the way issues are shared with regulators. I guess it's some sort of clearinghouse model where regulators who have some ability to operate and share information across borders, across legal regimes, and to obtain information that we can't, would just make an outsized impact on solving this beyond just a new law change, a new law passing, which again, it's only in the US, so it's not gonna matter for some of these large operators.
Veronica, Mike, did you want to add to that?
With respect to regulators, I think the industry has to create some transparency around what exactly they want to mitigate against. Is it that they're worried that a competitor is going to come in and use their data to create a competitor? Is it that they're worried about the privacy of the individuals whose personal information they're stewards of? That's a legitimate issue. That's you're protecting the information. But there's a lot, when you read some of these cases, when you read some of the information out there, there's a lot of, well, scraping is bad because of X, but the underlying issues seem to kind of be a little bit grayer. They meddle in terms of competitive versus personal information. So really speaking, getting people together, MUSA is great for this, right? Like you can have a standard, you can have transparency as to what is it we're trying to protect against, what is it that we're worried about in that space, and bringing into the public good and the scientific research side, making sure they have a seat at the table and that we're all transparent as to what it is to be unauthorized scraping versus what is the impact to the individual, the impact to the actual company.
I think it's a few things. I think the biggest problem today is the platform is the only one held accountable for these actions. We talked about Clearview AI, but when the fines are a fraction of what has been given to them by individual VCs, it's where is the harm and where are the teeth in this? And it's the other folks that scrape. It's when they scrape, when they create these data sets that they trade, when they become a data broker, when they set up the competitive or phishing sites, there is very little consequence for them. Any of us in this room can take a drive full of 5 billion records of information of consumers, as long as it doesn't contain health information, financial information, nation state information, and go sell it on any street corner in any street in any country and have zero consequences attached to it. Until some of that changes, it's going to be really hard and a really difficult shift. I will say, like, I'm also really grateful for MUSA and opening up the conversations. And I was fortunate to be a part of the MUSA event in the UK and the Tech UK, which I understand there's like a Tech UK publication came out today with some of the findings from those conversations, talking to the regulator directly and facilitating that conversation. That was very eye-opening for us and eye-opening for them. So I hope more and more of that continues to happen.
So a lot of, and I'm a perfect example of this. I came from some of the biggest companies in the world. What do you say to the small companies out there? How do they take on these challenges?
To basically use your resources wisely to protect your users and your platform as much as possible, to kind of work with organizations like this who can really help scale up industry-wide solutions, but also to kind of protect a vibrant and competitive economy that relies on data and competition and the ability for users to choose who to share their data with without it being locked up in one place.
At small companies, at startups, you don't have a lot of resources.
Yeah.
You don't. You've got one person working who's the CTO, who's also the CISO, who's also the CFO somehow. They're all working together. And I think that one of the most important parts for these small companies who are trying to innovate, who are trying to do these types of things. And again, I always split it. It's two sides. It's the company protecting from the scraping and the company wanting to scrape for some reason that might be unauthorized, right? Either way, you need, if you're the company trying to protect your data assets, you need to know what your data assets are and what value they bring to your company. So you understand your why. Why am I trying to prevent this unauthorized scraping? What is the issue at hand that I'm trying to prevent, the harm that I am trying to prevent? On the other side, if you are trying to innovate, if you are trying to do research, you also need to know your data assets. What are you actually trying to do? Like, do you have a legal basis for collecting this? Do you have a purpose? Are you just trying to see how much data you can get at all times? And like, you have to know your why, and that is going to influence how you approach it. You don't have a lot of resources, but you can, if you are very precise and you say, okay, I have user data, I have end user data, personal data, I'm going to protect it in this way, and here are the structures I can put around that. It really just depends, but really knowing your data assets, I think, is probably the most important thing.
I've really appreciated that some of the points you all brought up around, like, having the clearinghouse of information and making this available. I'll beat the drum again on frameworks. Like, all of us, that as we're developing them and can develop them as an industry and work with MUSA to share some of the best practices and other things, like, I think that's going to go a long way towards helping small, medium businesses. I think the more that companies that do invest can open source and do things around sharing findings and including transparency around some of these things, I think it's really important as well to, like, sharing these examples and helping identify the problems. I think, and then I also love the example of choose good. Like, you're building a startup, like, make sure that you have, you know the provenance of data you're buying or that you're either acquiring or getting somehow. And just because you buy it from somebody doesn't mean it wasn't gotten in ill-gotten ways.
So, well, first, I don't know if anybody noticed, but not been a perfect YouTube video that Veronica just did on how, if you're a small company, to handle scraping. But overall, though, we're now talking about companies working together, right? Let's talk about public, private. I mean, that was the whole point of why the alliance was formed in the first place, it seems like a good place to end it, which is what should be the public-private dialogue with regulators or other policymakers with the industry? How do we approach that? How do we get that dialogue to open up? I know Tech UK had an event about a month and a half ago. That was one of the first ones in the world. So it's now time for that. So how do we approach it so it's a success story as opposed to there was a battle that just didn't seem to get anywhere? Anybody want to start? Doug?
I think it begins with how we began today, which is figuring out what the shared goals are. And thinking, recognizing where the risks are from, from over or under regulating, that maybe there's more than one problem to be solved, and who the best partners are to get that done in both the public and the private sphere. I think it's really important to get all those stakeholders in the room to represent, make sure that kind of that full cross section are there, but also to take the time to go from discussion to the next step of kind of catalyzing some sort of initial action that maybe won't solve all the problems, but could get us part of the way there in a visible way that shows people something can be done so that it'll just get the ball rolling.
I've worked for large organizations, I've worked for small organizations, and I go back to like limited resources. Sometimes you don't have the ability to talk to regulators directly. You don't.
No.
But you can seek out peers in your industry and talk to them. What are they doing? What are your outside counsels doing? They have resources that are far above yours. So seeking out peers in the industry, aligning on your goals, aligning on what you're actually trying to do, and then looking for solutions there. I previously sat, SOMAR is a research organization. I previously sat on their legal affairs committee. We had a great opportunity as a representative for ComScore to go to the EU and talk to them and speak to regulators directly. You don't always get that opportunity in a smaller space. And so, but now we work with our outside counsels to do that type of commenting or to flag for us issues globally that we might want to address. So it's really just trying to see where you have the most benefit for the least amount of resources.
Yeah, it's I would agree with all of that. I think on top of it, it's it's helping identify what the industry standard is and really working towards like codifying that, because that we can't have regulatory conversations without all agreeing on what should be the expectation from a technology perspective or ability to enforce or obligations around research and other things. And so I think that is where the conversations have to start, and they're going to be difficult conversations because it doesn't exist. It hasn't come out of academia and it hasn't come out of the commercial space yet. I think one of the other places for small and medium businesses that I think is going to be really influential is like as they learn about their data being scraped, as they learn about unauthorized scraping, putting their business at risk, is also the people that produce the enterprise products, the managed service providers and others that can provide some of this at scale, where they themselves build these services for their own products in Amazon's case, in Microsoft's case, and others, and really working with where they're buying their services to help provide some of that protection, which will be much easier when we have frameworks. Did I say that yet?
That's actually perfect time to go to the audience if there's questions around this topic, since we're a few minutes left here. Since we're last panel, we're between you and the
Or to get a drink and then we'll answer questions.
But anyway, so any questions in the audience? We see a hand over here on the left.
Can you raise it?
Hi, can you hear me? Yeah. So I think one of the things that I took away from this session, which is that slightly different from the sort of discussion we had in the previous sessions, where I think we were more categorical about, the panels overall, or were more categorical about scraping needing to be banned as a policy position and like limited exceptions perhaps being made in certain cases. But I think one of the things that Veronica pointed out is that that might not necessarily be the best solution because you're looking for something that's more of a balance between companies like Microsoft and companies like Jumio. And so I was wondering, do you feel that instead of privacy laws being the way forward, which was the takeaway from the past session, something like a self-regulatory framework or partnerships with industry bodies, as you pointed out, would be like a better framework? And like, is that something that you think would work better as compared to a law?
We do not scrape.
No,
I'll
I mean,
start with-
like not scraping in that sense, but like
not part of our product or our model. And I have issues with self-regulatory frameworks. I don't always think that they are the best route. They don't always work very well. But that being said, I think it is, in the last panel, they talked about this. I don't think there's one solution. I think it is 10 different solutions at different types of levels so that you do have more enforcement on the people who are misusing the data. Why should a company who is protecting the data to the extent they can be penalized when there's a company on the other hand that is just doing what they want and it's a Wild West? So you really have to, it's not one over the other, it is all of the above, and trying to figure out what those controls are that you're going to put in place that actually click in that moment in time. And then knowing that even though it's in that moment in time, technology is just going at a pace that the law cannot keep up with. So knowing that it is not a point in time solution, but that these types of things that you're doing are going to have to change as technology changes and the world changes.
Anyone add to that?
I think it's one of those things like buying a bike at a pawn shop. Was it stolen or not? And I think that's it's less about self-governance of the companies on, because we have so many sides to this marketplace. We have the companies that where data is scraped from. We have the companies that are doing the scraping. And then we have customers of the companies that did the scraping and perhaps customers of those customers. And so it's really understanding the provenance of data. It's really setting expectations in the same way that we have expectations that the data center we're using, has, certain environmental and green features, that we're not wasting electricity and wasting other natural resources. We should have the same expectation around data that's passed through a marketplace as well. We should, we have to build these expectations, and that's where, I don't know that a law today is necessarily that, but when we lack the judicial precedent for any of us to really have full teeth and enforcement in all cases, and for us to be able to enforce on all kinds of scraping that is bad, or even just observe it and know it's happening. I think that was an interesting thing that I heard earlier is, I don't think scraping is as observable as people think it is and what it takes to actually identify it.
Other questions? No other questions?
There's another one more back.
there.
Last question.
Are you sure?
You don't want the reception?
Thanks. I think at the outset you talked about getting rid of the supply of data, but the demand continuing to go up, and that a lot of the folks who have been on these panels, either privacy professionals or work at bodies or companies where user data and data in general is a vehicle for monetization for the company, but also kind of part of their IP. But that monetization piece is really kind of where the friction, we haven't really invested as a space in creating that friction. So what do you all think about entities, throwing out companies like Stripe, who don't necessarily have data to scrape, but are the mechanism through which the monetization for scraping happens? So how do we take MUSA or this privacy space in general and expand it to parties that aren't directly involved, but are the ones who are used by legitimate or illegitimate actors to make money off the data that they're scraping?
In a way, what I'm hearing from that question is the supply chain. How do you attack the supply chain? Anybody want to answer?
I think attack's a poor term, because I think companies have dealt with this, especially through fraud and especially through other things that have happened. Stripe is in a really tough place in a lot of cases, but they make a lot of money along the way. And so figuring out a balance of, when a violation occurs of terms, it's hard. Are we going to hold Stripe accountable to your terms of service and somebody violating it? And that's where, like, unless it's actually violating a law, like, it creates a lot of challenges. And it's just, it goes back to the heart of the gaps in the regulatory space. The gaps of any of these actions being illegal makes it really difficult for them. Makes it difficult for app stores. Just because somebody's violating your terms of service, does that necessarily mean it's a violation of the app store's policies? And I think that's a to be debated case that hopefully MUSA tackles.
I'll just say, essentially, that issue is a trust and safety problem. And trust and safety problems, the less clear the rules are, the harder they are to resolve, which is a whole other issue I think all three of us deal with sometimes. So resolving the other questions we have here would make that type of secondary enforcement a lot easier too.
Right, and I think what that basically boils down to is collaboration. Sometimes collaboration can solve problems that the written word cannot. So with that, I'm gonna thank our panelists. This was a fascinating conversation, and I do wanna give you all, if you have anything else you wanna add before we let these folks go to the other side of the wall. Anybody?
None of this was legal advice.
I am more privacy people.
I'm really excited to see, I heard we had hundreds of people online, so I appreciate like MUSA putting this together. It's a big deal. This is a conversation. Like I said, I don't feel lonely like working in this space because I've gotten to meet a lot of other folks today and talk to a bunch of other folks here and hopefully meet more of you over time. But I really appreciate HeyMu, Venable, MUSA, and everything and everybody for pulling this together. It's a great start. I have never sat through a first one of these conferences from kind of a trade association perspective where there weren't just the three people that sent out the invites sitting in the audience. So thank you so much.
Thanks a lot. I do want to say, and I truly appreciate that, and thank you for that kind word. I want to first wrap it all up for you. And magically, my team knew what the takeaways were going to be, and they wrote me a speech. So this was one of the first of many. As Mike was saying, usually you do get 3 people in a room when the alliance forms and you hold a meeting. We had over 250 online guests registered and over 50-something people in this room. That to me is absolutely fascinating. What did we learn today? We learned that a dialogue has to happen. The challenge around defining and regulating unauthorized scraping is incredible, but it's solvable, and it over time will be more and more and more successful. The other is the importance of understanding and addressing user impact. A lot of times people wonder what that is. One of the things we're hearing from this panel as well as the others is there is a conversation to be had to better understand that. The third is the importance of understanding the unique challenges that companies face. I think if you hear from the different companies that were represented, they all brought a different perspective, a different challenge, a different purpose, maybe this is not one problem I need to solve, but it is for somebody else. That one is mine, that one is yours. And yet there's a collaboration need, and there's a huge opportunity here to identify the solutions and foster a public-private dialogue. I think one of the first things that we started a while back was, how do we make that happen? And we realized the way you make it happen is you create a really fancy logo and tell people it's an alliance and bring people together because they show up, especially in Washington, DC. But then we go from here. You're going to see more of these conversations, whether it's around how do you attack this issue? How do you bring collaboration? How do you foster that discussion that's happening, not only in the audience, and I'm sure many of your thoughts are going through, I have a question, maybe I don't want to ask. Well, there'll be so many opportunities to do that. So before, though, I do let you go, I do have to do something that's always important, sometimes forgotten, is thank certain people that I'm going to call your name and you have to stand up because you're on live TV right now, so you got to stand up. So first one is Maya, Nicole, Paige, Sarah, and Ashna. Where are you all? You got to stand up and take a round of applause here, because these are the folks that put this together. Without this, none of it would have happened. Without all the efforts they put into it, we wouldn't have had this kind of dialogue happen today. So if you want to learn more about MUSA, go to the antiscrapingalliance.org website. It's listed somewhere in the little fancy things that you got at the door. And now it's time to do what everybody's been waiting for, networking, reception on the other side of the wall. So thank you all for coming and have a good evening.